completed the exercise where you gave your comments to the version that Mr. Min had put up on behalf of Bain in the Bain application to cross-examine. You recall?
I do, Chair.
Yes, that brings us to the end of your testimony, and I just wanted to know, is there anything that you wish to say to the Commission in conclusion?
Chair, if I may, this testimony and the last 18 months of me leading up to coming here has been incredibly hard for me. To say the things I did about Bain was not easy because these are my friends. These are people I've known for over 25 years. They gave me a big career break. So I in no way made those statements likely if I didn't believe they were in the interest of South Africa. I decided to resign from Bain, even though I had an incredible offer, an incredible job at Bain, because it became clear to me that Bain were far more interested in managing and protecting themselves from a DOJ prosecution or investigation in the US than making amends in South Africa. And I made it very clear to everyone at Bain that understood that that's how I saw things happening. Chair, just one comment that sort of wraps it up for me, this attitude towards South Africa, is an email in my submission to you where what the Bain manager says to a Bain partner, if you're going to see Mr. Moyani at SARS, tell him his procurement and legal people are a bunch of losers. And it's in my affidavit. And for me, this captured the sense of these people in South Africa are irrelevant to us. We will just do what we want. For me, the SARS legal and procurement people were defending South Africa, defending the rules, defending our procurement, defending our democracy. And for a senior Bain person to say they're a bunch of losers because they were resisting what we were trying to do, captured for me what I thought was wrong with what was happening at Bain, and that's why I had to leave. Chair, I want to add my voice to two things which you've already heard in the Commission. The one is this desperate need for protection and support of whistleblowers, which you have said desperately needs to happen. And of course, I speak about that from my own experience for the last 18 months, which, Chair, has been a horrific experience. The fear I've suffered, the intimidation I've suffered, the legal and financial uncertainty I've had to face. Chair, 18 months ago, I had this perfect career. I was a part-time partner at Bain. I was a senior lecturer at UCT. Today, as I sit here, I'm unemployed. And as I understand it, I'm unemployable because it appears to me that corporate South Africa is uninterested in people with integrity. The horrific cost I've experienced is not just the fear, the legal, the financial cost. It's been the cost of my health and the cost of my family. And Judge, no amount of reparation and remedy can make up for that cost to your family. People ask me if I've got regrets about what I've done. I said I've got absolutely no regrets for what I've done, even though the high cost I've incurred. But I do regret the damage it's done to my family and the stress to my family. So to my family, I apologize. Judge, just to add to the second thing, the first thing, I'm going to add my voice to the appeal of protection for whistleblowers. The second thing is to hold these enablers of state capture accountable. And we know, we can talk about the banks and the corporates and the accounting firms, and of course we know about all of these, and there's a lot of efforts around those. I just want to also add my voice to that need, to hold these enablers accountable. And what's interesting, Judge, I think there are some secondary enablers. There's the enablers we know about, and then there are companies out there who are continuing to do business with these companies who are involved in state capture. And I think they're also part of this web of state capture. I mentioned to you that I had my job at UCT. Chair, I was teaching ethics to business leaders and public sector leaders. That was what I was doing. When I blew the whistle and stepped forward, UCT asked me to leave from the business school because they said, you're doing all these Zondo stuff, you're doing all these things, you're writing your affidavit. Chair, to write my affidavit, 700 pages, I did it myself. No law firm in South Africa would offer me support. Even the Commission said you could offer me no legal support. I wrote that sitting at my desk at home with Google at my side, trying to figure out what to write and how to do it. UCT then said, well, then I'm neglecting my duties as a senior lecturer, and they asked me to leave. This is the experience all whistleblowers have, where they don't have the support where they are. UCT continues to do business with companies that are involved in state capture. So I want to lend my voice to that call for us to hold accountable these enablers. And that's been my call to Bain all along, Chair. All I wanted from Bain was to make full disclosure and then make amends for it. That was what I was interested in. I launched a public campaign recently to urge Bain to make full disclosure, and that had 2,500 signatures, South Africans saying, yes, that's our call. So, Chair, just in closing, if I may, as a social philosopher and as a moral philosopher, and I know I must go and finish my PhD still.
You must finish it.
I must finish that. I'll come back to you when I'm done. But, Chair, it strikes me that we in South Africa are living in an era of the bully. We can talk about corruption and greed and all the rest of it, but I think we've got a culture where bullies dominate. Politicians bully the civil servants bully citizens, corporate leaders bully their employees, and they can bully and do this because there's lack of accountability and no consequences. And so I think this is why the bullies get away with it. Bullies are emboldened in our society. We see it with gender-based violence. The bullies feel they can get away with anything. The gangsters feel they can get away with anything. So in my view, we've got to stop these bullies. We need to move from this era of the bully to the era of the brave, of politicians now being brave enough to stand up to these bullies, of legislators willing to go and institute laws to stop these bullies. Because I can't see us moving out of this world of corruption when we all live in fear. Because when I speak to people in companies saying, you've seen corruption there, why don't you speak up? And they talk about the fear they face. And so we need brave people like our civil servants, our corporate leaders need to be acting, brave people like our healthcare workers, our school teachers, our nurses. And I think brave people like whistleblowers who stand up and act, not just for themselves, but in the interest of our country. And Chair, just in closing, I wrote that email to Bain in September 2018 when I first got involved, where I said, my hierarchy of interest is South Africa first, then myself, then Bain. And I think we begin to move the needle in South Africa, this moral inflection we're at, when corporate leaders, business leaders, lawyers, citizens are willing to act in a way beyond themselves, but in the interest of our country. Thank you.
Well, thank you, Mr. Williams. Just 2 or 3 things. One, you mentioned that the Commission could also not give you or offer you lawyers. I assume that what you mean is that they couldn't say, get a lawyer that the Commission will pay for you, because otherwise members of the legal team, it's their job to interview people who want to give evidence and prepare affidavits for them. I was told at some stage, because I think, as you said, it's been a long journey between yourself and the Commission since you started. Contact was made between the Commission and yourself, that you were looking for lawyers to assist you, and I assumed maybe in Cape Town. So I just want to have clarification that whether you are talking about members of the legal team refusing to assist you, or whether you are talking about you being told the Commission can't pay for your lawyers. Is it the latter?
Chair, it strikes me that there's a third option there somehow.
Yeah.
I was lost, right? I was getting calls from Bain people, Bain lawyers, they were threatening all sorts of things. And so I was just confused, afraid, not knowing what to do. And so I approached the Commission and said, if you asked me now to write an affidavit. That was never my intention. Initially, you asked me for documents. I sent you the documents. Then you said, write an affidavit. And I said, how do I write this affidavit? And after I contacted the law firms who said they couldn't because they were conflicted, I still said, I don't know how to write an affidavit. Can some legal person help me with this? So whether it's a Commission legal person or a legal person the Commission pays, for me it was irrelevant. It was just I needed help to do this thing because I knew this thing was going to be an important document. And even now when I see Bain comment on things I said in my document, it's possible I've caused trouble for myself because I sat down and just wrote this from what I knew.
Well, I'm surprised if that's the case because the legal team performs the task, but sometimes some people prefer to have their affidavits prepared by their lawyers, and then their lawyers keep in touch with the members of the legal team. But the first thing is that they would be saying, that is the legal team, can we interview you and take a statement do an affidavit for you. But it's your choice if you say, no, I've got lawyers, I'll get lawyers to do that for me, and then they can send it to you. You say that's not...
Chair, I met with the investigators and I apologize that they can speak for themselves. At no point did anyone from the commission offer to write an affidavit for me.
Yes,
I was asked to write an affidavit.
yes. Okay, I'll find out how that happened or hear what they have to say, and the commission will be in touch with you in regard to that, because, as I say, the idea is that members of the legal team are the ones who do that. The investigators also do that.
Yeah, I paid for my own travel to come here.
Yes.
So I don't know.
Well, in terms of your own travel, the commission should be able to take care of that. Was there any discussion about your traveling expenses?
Not this time. Last time there was.
Is that so?
Yeah, but I don't want to waste your time, Chair.
No,
on this.
but that's fine. Since it's good, Mr. Franklin is there. He hears what you say. I think he will talk to his team, and somebody in his team will try and find out what the position is. But you certainly shouldn't have paid your own traveling expenses to be here. And as far as I'm concerned, the commission should refund you. But apart from that, I wanted to also ask, and Mr. Franklin might be able to say, we didn't cover this, but of course we're working within time constraints. I thought there was a portion in his affidavit that dealt with attempts by Bain to, I think in your words, to silence you or something like that. Was that oversight not to cover it, or because he said he confirmed it?
Yes, Judge,
Yes.
we decided for a variety of reasons,
Yeah.
some of them time,
Yes.
that it wasn't directly relevant to the extent that the remainder of the evidence was relevant.
Yeah.
And for that reason, it wasn't covered in oral testimony. Of
Yes.
course, it is still in the affidavit.
Yeah.
And Mr. Williams has confirmed its correctness.
Yes. No, that's fine. But other than that, Mr. Williams, I do want to reaffirm that I believe that we should have a strong protection for whistleblowers in our country in terms of legislation. There should be strong protection, because if whistleblowers were not there, maybe half of the things that we know about state capture and corruption in South Africa we would not know. So it's very, very important. So if you have suggestions or submissions you want to make, feel free to write something and send to the Secretary of the Commission. I've extended the same invitation to other people. I think we should have a strong protection, because if we don't have a strong protection for whistleblowers, then our fight against corruption will be weakened in a very significant way. But I also then take this opportunity to thank you for taking the time to avail yourself to come and give evidence before the Commission, and for the fact that also you have not been discouraged from coming to assist the Commission. We appreciate it very much.
Thank you, Judge.
Thank you.
Thank you, Mr. Williams, for your testimony.
Yes, you are excused. Do you know whether you would need a few minutes adjournment, or we can go
I
straight
think
away?
we can commence immediately.
Okay.
Thank you, Chair.
You can call the next witness.
Thank you. Our next witness is Mr. Flock Symington.
Remember to sanitize the file as well.
Chair, if I may place myself on record again.
Yes.
It's Greg Fourie from the Johannesburg Bar. I appear for Mr. Symington. I'm instructed by Mr. Bernard Hotz of Worksman's Attorneys. Thank you.
Thank you. Yes, Mr. Franklin.
Thank you, Chair. Good afternoon, Mr. Symington.
Afternoon, Mr. Frank.
You should have in front of you a file which is marked SARS Bundle 02.
Yes.
Could I ask you to open that file?
Before he does, let's have the oath administered to him or affirmation. Registrar, have they taken your mic? Well, somebody must look after the mic, and if it's given to somebody else, they must make sure it's returned. Otherwise, we will be delayed when there is no mic. Okay, please stand up, Mr. Symington, for the oath or affirmation.
Mr. Symington, will you be taking the oath or affirmation?
Yes. Affirmation.
Okay. Please state your full names for the record.
Johan Daniel Rock.
Just 1 second. I'm not sure if they can hear you there. Maybe you might have to speak up a bit. Can you hear? Could you hear Mr. Symington? Okay, just speak up, Mr. Symington.
Sure.
Yeah.
Please state your full names for the record.
Johan Daniel Rock. Saming.
Do you have any objection to taking the prescribed oath, affirmation, sorry?
No.
Do you affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth? If so, please raise your right hand and say, I truly affirm.
I affirm.
Thank you. You may be seated. Yes, Mr. Franklin.
Thank you, Chair. I had asked you, Mr. Symington, to have available before you SARS Bundle 02. Do you have it?
Yes, sir.
And would you please turn to page 116? And could I just orientate you throughout these proceedings? I will ask you to turn to the page which appears on the top left-hand side of the page in black numerals. Page 116 is the commencement of an affidavit by yourself, is that correct?
Yes.
Please turn to page 171.
Mr. Symington, I'm sorry. Just want to confirm, when you were responding to the registrar, when she asked you to give your full names, I heard as if you were pronouncing your surname as Symington.
Yes,
But
sir.
is it Symington,
Yes.
not Symington?
Well,
both.
it's
Okay.
up to you, Judge.
Okay, no, that's all right. No, I just wanted to make sure I used the correct pronunciation. Okay, all right. Mr. Franklin.
Thank you. I need to correct myself as well. Mr. Symington, at page 171, it appears that you signed this affidavit on the 2nd of November 2020. Is that correct?
Yes. Okay, that is correct.
Can you confirm then that the document at page 116 to 171 is an affidavit without annexes to which you attested on the 2nd of November 2020, and that it is truthful and accurate in all respects?
Yes, Chair, it is.
Thank you. I would like to take you to a number of different topics. We'll do so with reference to the affidavit and to the annexes which you have attached.
Do you want me to admit it, Mr. Franklin?
Yes, please. That should be admitted as Exhibit WW3. Thank you.
And you said without annexures, it doesn't have annexures.
No, it does. So
Oh.
the affidavit with annexes should be admitted, please.
Yes, okay. The affidavit of Mr. Johann Daniel Flock Symington, which starts at page 116, will, together with its annexures, be admitted as an exhibit and will be marked as Exhibit WW3. Okay.
Thank you, Chair. Mr. Symington, some background facts first. By whom are you employed?
Chair, I'm employed by the South African Revenue Service.
In what capacity?
At the moment, I'm a senior executive of SARS in the executive committee of SARS. That's where I am at the moment.
And since when have you been employed by SARS?
I've been employed by the head office of SARS since the 1st of April 1990.
So it's for more than 30 years.
Yes, Chair.
And what field are you in at SARS? What services do you provide for SARS?
So, Chair, that is arranged over the years. On the 1st of April, when I joined the head office of SARS, I was actually dumped in the deep water by having to take care of the matters relating to pension funds, provident funds, retirement annuity funds, and so forth. Over the years, my career has developed into what we call personal income tax, and that at the moment is my field of expertise.
And would you let the Commission know what your qualifications are?
Yes, Chair, although I must mention, having heard Mr. Williams' I'm
You're not so confident
I
to
am
mention yours.
hesitant, but I will share with you.
Yes.
So I've got a BCom in financial management and LLB.
And is it correct that during your tenure at SARS, you have inter alia provided legal advice to the organisation?
Yes, Chair, on many occasions.
You mentioned earlier pensions and provident funds. Do you have any particular knowledge and experience of those?
Yes, Chair. One must understand that where SARS fits into that area, because it is not that obvious, but the fiscus incentivizes people to save for their retirement via a pension fund, and it uses the Income Tax Act to incentivize that by making sure that the fund itself is exempt from tax, that contributions to the fund is deductible, and so on. And that is where a SARS fits into the area. Now that, of course, allowed myself and a team that I worked with to engage very intimately with the retirement fund industry. At that time, it was the industry was represented by the Life Officers Association. Now it's called ASISA, if I remember correctly, as well as the Institute for Retirement Funds. And over the years, we have built up a very workable relationship. And one or two examples of that would be what we know today as preservation funds. That vehicle was developed between myself and the LOA and the Institute for Retirement Funds. Another example would be what we refer to as living annuities or equity-linked annuities. That, again, was a product that we released in the market together with the Life Officers Association and the IRF. So those were so I was very intimately involved in that industry. And as a result of that, I was acknowledged by both inside SARS and outside SARS as an expert in the field of pension law, if one can refer to that.
Thank you. Now, you are called principally to tell the Commission about the events of the 18th of October 2016, but in order to give that context, I'd like to go back to what you have dealt with under the heading Broader Background on page 117 of your affidavit. What you say in paragraph 6, Mr. Symington, is this: what follows under this heading is what I understand and am advised forms part of the public record or falls within the public domain and is regularly reported by the media. I do not have personal knowledge of these facts, but they are relevant to the context in which this affidavit is made. Now, the Commission has heard a great deal of evidence covering the issues which you have dealt with here, and so I'm not going to lead you through it. But in essence, what you have outlined here is the changes in the Ministers of Finance in 2015 and 2016, where Mr. Nene was replaced by Mr. Van Rooyen and then by Minister Gordhan. And you have also referred to allegations of state capture by Mr. SABC Jonas in January of 2016, and you have placed Mr. Gordhan in that milieu together with other officials in the National Treasury, and you have said on the strength of the facts that you have set out in the public domain that it appeared that inter alia Mr. Gordhan was an obstacle to parties involved in state capture. Is that an accurate summary of the background?
Yes, it is.
All right. So if I could then take you to paragraph 16 of your affidavit, it's also well known that accusations of criminal conduct were made against Minister Gordhan by the Directorate for Priority Crimes, also known as the Hawks. And you know also that during the early parts of 2016, it was widely reported that the Hawks were investigating a broad range of allegations against Mr. Gordhan, including alleged involvement in the so-called SARS rogue unit and other activities. Is that correct?
Yes, Chair.
Then could I ask you to turn to the first of the annexes to your affidavit, which is VS1, page 172. Am I correct that this is the covering letter under cover of which was sent to Mr. Gordhan by the Hawks a list of what has become known as the 27 questions?
Yes, Chair.
And you have highlighted in your statement questions regarding Mr. Ivan Pillay, and you have identified in particular paragraphs 21 to 25 of the 27 questions, correct?
Yes, Chair.
And those relate to Mr. Ivan Pillay and his functions at SARS and his application for early retirement and his engagement on an independent contractor contract. Is that correct?
Yes, Chair.
Now, that letter, as you will see, refers to a particular case number, and you have reflected that case number in paragraph 20, and that is CAS 427/05/15. And could you tell the Chair what that relates to, what alleged offences, and whether that later was expanded to include further offences?
Yes, Chair, I think I can elaborate on that. That number is the very same number that was used to lay charges in May 2015, if my recollection is correct, by Mr. Moyani against a number of names. So that is the number that was used in that sheet as well.
All right. Mr. Ivan Pillay, who is Mr. Pillay, and what was his position at the time that the events that we are talking about took place? So let's go back to 2009, 2010. What position did he hold at that time?
Chair, if my recollection is correct, and I'm speaking under a correction, he was heading up our enforcement area in SARS.
Right. Just continuing with the various charges, Mr. Gordon responded to the 27 questions we know, and then also it's a matter of public record that on the 11th of October 2016, the erstwhile National Director of Public Prosecutions, Advocate Sean Abrams, announced that various charges would be brought against Minister Gordon and also Mr. Opar Magashule, who was a former commissioner of SARS, and Mr. Pillay. Is that correct?
Yes, Chair, it is.
And those charges related to the approval during 2009 of a request by Mr. Pillay that he be allowed to take early retirement and that thereafter he be appointed by SARS on a fixed-term contract basis. Is that correct?
Yes, Chair.
And is it correct that at that time you furnished a memorandum to the then Commissioner in which you expressed various views?
That was then in March 2009.
Right.
Chair?
Could I take you, please, to the document which appears at page 202. Is that the memorandum that you speak of?
Yes, Chair. That is the yes, Chair.
And who was it addressed to? It's addressed to
It
Commissioner,
was
but who was that?
the commissioner at that time was Mr. Gordon.
And what gave rise to the request for you to provide this memorandum? What was its purpose?
So, Chair, I was asked by Mr. Pillay to write a memo to the commissioner on these matters that I raised, or that he raised with me. And that then related to the application, the lawfulness of him wanting to go on early retirement, and the lawfulness and the availability of the provisions in the Public Service Act, which allows the minister to allow somebody to go on early retirement. And then the third item that he asked me about was the lawfulness of being appointed after his retirement at a SARS. And that is the context of it.
All right, we can read the opinion ourselves, but what was the conclusion to which you came, and what did you advise the Commissioner?
So my advice was very cryptic, and that's the way that we would normally write to a commissioner. And in Mr. Gordon's instance, as an example, when he went to somebody to ask for advice, he knows where to go, and so he's never really interested in the detailed setting out of the law. He's interested in my research outcome of the law. And so I advised in broad terms that that all three, 1, 2, and 3, or 1 or 2 or 3, is lawful.
Right, we'll return to that in due course. Then could I ask you to look at the document at page 204 and following. Is that a letter which is addressed by by Commissioner Magashule, dated the 12th of August 2010, to the then Minister of Finance, Mr. Gordhan?
Yes, Chair.
And we can read it, but is it correct that the Commissioner sought the Minister's approval for this, or these issues that you had opined on in your memorandum of the 17th of March 2009, i.e. the application for early retirement, the waiving of the early retirement penalty, and the request to be appointed on contract after his early retirement?
Yes, Chair.
And then, if you would look please at page 207, at the bottom of the page, there's a date, 18 October 2010, and there is a signature, P.J. Gordhan, Minister of Finance, and it is indicated as having been approved. Do you know what the Minister was approving?
Chair, I must just mention that I was not involved in this letter. So this is what we know that was sent to the Minister, but this would have been the Minister approving the recommendation under 6 on this same page. That is normally how we set it out. So we ask the Minister or to whoever we write, like the Commissioner, we make a recommendation, and that's then what is approved.
That took place in 2010. Now, jumping ahead, 6 years later, you have explained how the genesis of criminal charges that were brought against various SARS officials, it's also a matter of public record that a summons to appear in a criminal court on charges of fraud was served on Messrs. Gordhan, Magashule, and Pillay on or about 11 October 2016. That prompted a letter from an NGO which wrote to the National Prosecuting Authority and essentially indicated that there was no basis to proceed with the prosecution and that it should be withdrawn. Is that correct?
Yes, Chair.
Would you look, please, at the letter from the Helen Suzman Foundation, which appears as Annexure VS3 at page 193. You have that?
Yes, Chair.
We need not go through the full content of the letter, but what the attorneys acting on behalf of the Helen Suzman Foundation do is draw to the attention of the National Director of Public Prosecution certain materials which they regard as relevant in relation to the decision to proceed with the prosecution against these 3 individuals. Is that correct?
Yes, Chair.
Please look at paragraph 6.5 on page 196. Now, having made an allegation on the previous page that the charges are unsustainable and may in fact be actuated by recklessness or ulterior purpose, the following is said in para 6.6. The position is simply reinforced by the following contemporaneous documentation related to the retirement of Mr. Pillay. And then there are various documents which are attached. Please look firstly at what is attached as Annexure A, which you will find on page 200.
Yes.
That is an internal memorandum from Mr. Pillay dated the 27th of November 2009, and the purpose is stated to be to explain that I have decided to take early retirement, as well as to request you to consider to recommend for possible approval by the Minister certain related matters that will flow from my decision to take early retirement. That's addressed to the Commissioner at the time, Mr. Magashule.
Yes, Chair.
Then, going back to the Helen Suzman letter, there is an Annexure B, which is also accompanies the letter, and that is a Legal and Policy Division memorandum dated the 17th of March 2009, which you find at page 202 to 203. That's your memorandum, is that correct?
That is it, Chair.
And then the third document is Annexure C, which is a memorandum dated the 12th of August 2010, which you find at page 204 to 207, which we looked at earlier, which is a recommendation made by the Commissioner to the Minister of Finance and ultimately an approval by the Minister of Finance. Is that correct?
Yes, Chair.
And on the strength of these documents, you see that the Helen Suzman Foundation called upon the NDPP to unconditionally withdraw the charges, failing which they would bring proceedings. Is that correct?
Yes, Chair.
Right, I'd then like to take you, please, to paragraph 29 of your affidavit, which is at page 122. Now, you say that a Dr. J.P. Pretorius was instructed by Mr. Abrahams to reconsider the charges in the light of the allegations made in the full, as it's been called, FUL, Helen Suzman Foundation, letter of the 14th of October 2016, which we've looked at. Who was Dr. Pretorius?
Dr. Pretorius is employed by the NPA, okay, and he was also the author of the letter that was sent to the Hawks and that was asking me to make an affidavit on the 18th of October 2016.
All right, you've called that the Pretorius letter, and we will come to it in due course. But the essence of it is that the Pretorius letter, as you have called it, contained a set of questions to you regarding your 2009 memorandum. Is that correct?
Yes, Chair. And that happened because of what the evidence leader referred to earlier, the submission was it by the Helen Suzman Foundation and another one that included my memo of 2009, and I suspect the NPA wanted to know more about this memo, and so I received this letter with a number of questions they've asked me about.
All right, before we get to the events of 18 October 2016, subsequent to that, it's a matter of public record that on the 31st of October 2016, Mr. Abrams convened a further press conference in which he announced that all the charges against Messrs. Gordhan, Magashula and Pillay were withdrawn with immediate effect. Correct?
Yes, Chair, that is correct.
So, very shortly after having announced the bringing of the charges, they are withdrawn. Would you look, please, at Annexure VS4? You will find that at page 221.
Yes, Mr. Franklin.
That is a written media announcement by Advocate Abrams, dated the 31st of October 2016. Is it your understanding that this was presented to the press on that day?
Yes, Chair.
It's a lengthy memorandum, but I want to please identify certain parts of it. Please look at paragraph 14.4 on page 224.
Yes.
Now, it is said there, Mr. Pillay first applied to go on early retirement in December 2008 when a vastly experienced human resource specialist in the employ of SARS was requested to prepare a memorandum for the early retirement of Mr. Pillay. Do you know who that vastly experienced person was?
Not really, sir. Chair, that... No. I
Then, please look at over the page, at page 225, paragraph 14, the memorandum was for the attention of the Commissioner, who was Mr. Gordhan at the time, to recommend to the then Minister to consider approving the early retirement of Mr. Pillay in terms of the provisions of Section 16(6)A and B of the Public Services Act. And if I could take you forward, please, to paragraph 27 on page 240. And what is said here is full and the HSF also inter alia place reliance on a memorandum from a SARS Legal and Policy Division employee, Mr. Flock Symington, dated the 17th of March of 2009. That's your memorandum that we've looked at.
Yes, Chair.
Then in paragraph 28, what Mr. Abrams records is that this document only came to the attention of the prosecutors for the first time by way of the submission by Full and the HSF, and is advice to the Commissioner of SARS as a result of Mr. Pillay having requested him to consider, 1, his application for early retirement from the GEPF, 2, his application to the Minister of Finance to waive early retirement penalty, and 3, his request to be reappointed on contract after his early retirement from the GEPF. And then in paragraph 29, the advice that you gave is set out and summarized. Do you see that?
Yes, Chair.
Then going forward to paragraph 33 on page 245, what Mr. Abrams says, the advice of Symington appears to have largely influenced Mr. Pillay and Mr. Magashula. And then he says in para 39, I foresee great difficulty in proving the requisite animus. You are a legal person. Do you understand him there to be talking about the intention to commit a crime?
Yes, sir. Yes, Chair. Mens rea.
Then please look at paragraph 38 to 41. What the conclusion is by Mr. Abrams is, as a result, and in the absence of any other evidence to the contrary, I am satisfied that Mr. Magashula, Mr. Pillay, and Minister Gordhan did not have the requisite intention to act unlawfully. 39, I am of the view that the matter could easily have been clarified had there been proper engagement and cooperation between the Hawks and Mr. Magashula, Mr. Pillay, and Minister Gordhan. 40, in the circumstances, I have decided to overrule the decision to prosecute those three gentlemen on the charges listed in the summons. As such, I have directed the summonses to be withdrawn with immediate effect, and there would thus no longer be any need for Mr. Magashula, Mr. Pillay, and Minister Gordhan to appear in court in respect of the charges listed in the aforementioned summonses. Now, have you read that press announcement yourself in preparation for this hearing?
I've read it, not now, but in 2016 I did. Mr. Franklin, just, Mr. Chair, what is not very clear to me, if one look at the 39 on page 246, where Mr. Abrams says that in the, he says, I am of the view that this matter could easily have been clarified had there been engagement between the Hawks, Mr. Magashula, Mr. Pillay, and Minister Gordhan. Now, that may very well be so, but this memorandum of buying, dated March 2009, was in the hands of Mr. Moyane since December 2014, up to about 6 months later. And that happened to be in the hands of Mr. Moyane because he asked for Mr. Pillay's HR file. Well, he didn't ask for it, Mr. Pillay, we learned, asked for it, but it landed ultimately not in the hands of Mr. Pillay, it landed in the hands of Mr. Moyane, and it was kept in his office under lock and key, from what I understand, for about 6 months. Now, my memorandum was in his file, and I know that because HR confirmed that to me not long ago by way of an email. So it was, one would have expected that that when the Hawks had talks with Mr. Moyane, that he could have made that memo available to the Hawks as well. And I just wanted to add that.
Yes, thank you. Mr.
Well, I'm sorry, Mr. Franklin. There was clarification provided yesterday and I think previously in regard to the evidence of Mr. Gordhan and Mr. Moyane during cross-examination, that in the criminal complaint that Mr. Moyane had laid with the police, he had not included Minister Gordhan. I wonder whether that may have, in relation to Mr. Pillay's early retirement, that may have anything to do with the fact that he was aware of this memorandum. You might not be able to say
I would
anything.
not know that, but
Yes, you would not know that.
all I can say is that it was about, but it why it was necessary for this letter. But on normally, if we have to reveal what we refer to as taxpayer information or SARS information, we would have to get the permission of the commissioner when it's just normal SARS information, HR matters. And if it's a taxpayer info, then we are not allowed to share it unless ordered by a court. And so I'm not sure what the reason is for this letter to have went out, but it did.
Yes, and what it says, it's a letter from the then Commissioner, Mr. Tom Moyani, dated 19 October 2016, to the Colonel, Head of Organised Crime, and the caption is CAS 427/05/2015. Is that the criminal case number that we referred to earlier?
Yes, Chair. And if I may,
Yes.
Chair, the relevance of it, and this also goes back to the 27 questions that were posed to Mr. Gordon in February 2016, where this number was used as well. But it shows that somehow that matter, a case number has morphed into something which was not initially there. It may have been in the minds, because ultimately when you look at these things and you look at the way that the charges were framed, ultimately it would have led to Mr. Gordon. So even though his name wasn't mentioned there was a likelihood that whether it's the rogue unit or whether it's the pension fund matter, it may have led ultimately to Mr. Gordon in any event. But that's the relevance. So even on this date, which was very soon after the incident that we will come to later, then refers to myself and Mr. Lowe. I don't know why Mr. Lowe, but it refers to me. So this reconfirms that in the mind of Mr. Moyani, who's the author of this letter, he was a complainant in this matter, and he says so. So when one goes to paragraph 2 of that very same letter, he says in the second sentence, now it reads a bit weird, but it says, as a complaint in this matter, and I assume it must read as a complainant in this matter, I have to ensure that all relevant SARS officials, and then it goes on. So in his eyes, he sees himself as a complainant in a pension fund matter, because that's where I was involved.
But just to clarify then, the original complaint under this case number, CAS 427, related to the rogue unit, you said that then morphed. What did it morph into?
Mr. Chair, it morphed into an investigation in the validity or the lawfulness of the early retirement of Mr. Ivan Pillay.
And was your role in regard to that matter, was your role acknowledged by the Hawks, maybe, and Mr. Moyane as simply the memorandum then that you provided, or was there an allegation that you played any other role in regard to the early retirement?
So, Chair, at this stage,
as you understood the position.
I'm
So
not with you. I'm sorry.
Yeah, let me repeat. I just want to know from you what your understanding was of what it is that you were said to have done that was unlawful or criminal. So in relation to the early retirement matter of Mr. Pillay,
Yes.
were you alleged to have done anything wrong other than the provision of that memorandum of 2009?
No, I was never, no, sir. No, Chair.
Yes.
Never.
So was your understanding that whatever charges they had in mind for you, it was because of that memorandum that you provided?
Are you now referring to the aftermath, the
The
disciplinary
early retirement.
charges?
I see that in this letter at page 293, your name appears there. And
Yes.
that refers to that criminal case in Brook Lane. And I understood you to say it morphed into a matter relating to the early retirement.
Yes.
Or did I misunderstand something?
No. So, and that is also my, why I don't really know why this letter was, is there. It happens to be a day or two after the 18th of October when that incident happened at the SARS offices involving myself. But no one from SARS ever asked me about that memo of 2009. So I don't know why really he thought that I should have this sort of a permission.
So just to
Mr.
clarify,
Franklin.
Chair,
Yes.
this does not relate to any criminal charges against the four people. It relates to permission which is granted by the Commissioner for these people to give information to the Hawks.
Oh, I thought that the giving of information was related to the early retirement.
Yes, but it's not as though they were themselves the subject of the
Oh,
criminal
it
complaint.
was not, okay, no, that clarifies it, yeah.
Yes.
Thank you, Mr.
You've
Franklin.
dealt with this in your statement at paragraph 87, where you talk about this letter of the 19th of October 2016, and you've explained in para 88 that the four employees mentioned in that letter had no involvement or knowledge of events relating to, I'm sorry, let me just start again. The four employees who are there are yourself, Lowe, Pircha, and Gunn. And you say Pircha and Gunn had no involvement with or knowledge of events leading up to Pillay's retirement.
Yes.
Therefore, the Hawks would presumably have wished to interview them in relation to the alleged rogue unit of which Lowe and I had no involvement or no knowledge of. Clearly, the inference can be drawn that at the time Moyani signed this letter, he was aware that the scope of the initial investigation had been expanded to include the Pillay retirement issue.
Yes.
Is that correct?
Yes, Chair.
All right, could I then just take you back in the chronology of events? There had been the 27 questions, there had been the Helen Suzman Foundation letter, the Hawks and the NDPP were taking the criminal charges, well, they were reconsidering whether they should be proceeded with or not. And there was a request inter alia to Mr. Moyani as to whether or not there were any further representations or submissions to be made by him as to why the charges against Gordon et al. Should not be withdrawn. And could I take you to that letter at VS 22?
On which page?
Page 297 to 298.
Yes, Chair.
And what?
So,
Yes. Perhaps you can explain it.
Chair, so this letter was written by Advocate Abrams to Mr. Moyani on the 17th October 2016. And the purpose of this letter was to give Mr. Moyani the opportunity to make representations to the NPA about whether the charges should be withdrawn against Mr. Magashula and Pillay and so on.
I'm sorry, Mr. Franklin, I went to 297. That's not the page you...
No, that's the covering email. The actual letter is 298.
Okay, I've got it. Yes, continue, Mr. Symington.
So, Chair, I think also, if I may just, Mr.
Yes.
Franklin, Chair, what is also relevant of this letter is that the NPA, Mr. Abrahams, saw Mr. Moyani as a complainant in the very same matter, but nothing to do with the rogue unit, so-called rogue unit, but all to do with the early retirement of Mr. Pillay.
And this is the day before the events which I shall get to now.
Yes, Chair.
And on that day, Mr. Moyani had been asked whether he had any representations as to whether the charges should be withdrawn or not.
Yes, Chair.
All right, could I then take you to the events of the 18th of October 2016, which you deal with in your statement at paragraph 37 on page 124 and following. And could I ask you please to deal with that in your own words as to what happened? You have already sketched the background, and that is that you had been requested in a letter from Dr. Pretorius to answer certain questions by way of an affidavit arising from the 27 questions in your memorandum. Is that correct?
Yes, Chair.
So please can you take the chair through the events of that day as you have set it out in your statement.
So, Chair, I will give you an overview of it, I think, and then to the extent that you need more detail, you are of course welcome to ask. So, Chair, this day, which was a Tuesday, was like any other day. It was a normal day. I was asked in the morning.
And this was Tuesday?
The 18th of October
2016.
2016.
Yes.
Chair.
Okay.
And I was asked by Mr. Lowe, who was my direct line manager at that point. He was also a chief legal officer of SARS. I was asked by him to visit him in his office, and there he handed me a set of documents, which was the letter that was sent by Dr. Pretorius via the Hawks to Mr. Moyani. Mr. Moyani then handed that over to Mr. Lowe to ask me to do an affidavit on the questions that was on the letter. Now, those questions related to the March 2009 memo, which you will remember was handed in by the Helen Suzman Foundation just about a week or so before that, I think on the 11th. And so I went off, and Mr. Lowe also mentioned that members of the Hawks will be visiting me and I must hand over this affidavit, which I was then writing to the members of the Hawks, which is okay, which is normal. Nothing abnormal about that.
Did the letter ask you to do an affidavit, or you were doing an affidavit for the...
No, the
when
letter asked me to do an affidavit.
Okay.
If I remember correctly, we must just double check, but I did an affidavit.
Okay.
So I went to my office to do the affidavit. The Hawks arrived there at about 10 o'clock the morning, where I met with them, and we went through the letter, and then we made arrangements for myself to go and write the affidavit, and we also arranged that they would meet up with me again at about 1 o'clock on the same day. That I thought that I should be able to do the affidavit between that time and that time.
The letter from Mr. Pretorius, was its main purpose to ask you to do the affidavit?
Yes, sir.
Okay, all right. Continue.
And I just want to pause one moment at the, let's call it, a first meeting of that morning, which was a very good meeting. It was just a normal meeting. There were 4 members of the Hawks. I remember the names of 2. One was Brigadier Kaba, and the other was...
Is that Klaba?
Yeah,
X-A-B-A?
Yeah, X-A-B-A.
Yeah, that is Klaba.
Ah,
Yeah,
thank you,
okay.
Chair. And the other was Colonel Maluleka. And one thing that I was interested in, because I was alerted by somebody in my office that that memo of 2009 was actually out there since about the end of 2014, when there was a labor dispute between Mr. Pillay and Mr. Muyani. And so I was interested to know why they only now arrived at my office to ask me about this memorandum. And now my recollection of who said what is not so, but my recollection then is that Colonel Maluleka said, no, they only recently received it via the submission of the Helen Suzman Foundation. And I said, no, well, that is interesting, but to my knowledge, this memo has been out there for a number of years. Then Brigadier Kaba said, no, we've had it all along. Now, at that point, I didn't attach much value to it, and we went on. But in hindsight, that was actually something that one should think about, because if they had it all along, then why did the NPA not have it? So anyway, let me go on to... So then I went to my office, I did the affidavit. I was asked to do 2 more questions. So the Hawks added 2 more questions to the letter. I went off. The Hawks then asked to visit the offices of Mr. Lowe. And I then asked my secretary, Ms. Els, to accompany them there, assuming that they don't know where this is. And so she went off with them. And this is about a 5-minute walk, if you can call it like that. And when they arrived at the offices of Mr. Lowe, she noticed that they were not there. And then she and Mr. Lowe went to look for them, because they disappeared in a sense. Only then to find them in the boardroom of Mr. Muyani. And so now what was... what the reason for that was, I don't know, but those are the facts. Then at about 1 o'clock, we met again. I was not yet 100% finished with the affidavit because of those last 2 questions which were added to the delist. And I said to them, I need about half an hour to complete the affidavit. Now, that was in the meeting. Just about a minute before that, while I was in my office still, there was a man in the door which asked me to hand over that letter of the Hawks to him.
Mr. Pretorius' letter,
Yes.
addressed
Now,
to
yes.
that you were given by Mr. Lowe.
Yeah, yes.
Okay.
And I then mentioned to the gentleman that, I'm not yet done. I'm now off to the meeting with the Hawks, the 1 o'clock meeting. I will explain to them that I need about half an hour more. And I assumed that this man was also a member of the Hawks. Later on, after the event, it turned out it was the bodyguard of Mr. Muyani,
What's his name?
Mr. Titi, T-I-T-I. So when we then met in the boardroom, when I met with the Hawks again, Mr. Titi was also there. I assumed still there was now 5 members of the Hawks and not 4 anymore. I really didn't know that he was Mr. Muyani's bodyguard. I've never met him before. And and the meeting then all of a sudden was frosty. It was hostile. Brigadier Kaba asked me to hand over the Hawks, the NPA letter to him, and in return, he would hand over to me a copy of the very same letter. So it didn't make sense. Why would you want to ask me for this letter, but hand me the letter back again?
Mr. Symington, sorry to interrupt.
Sure.
You're talking about the letter that had been given to you at the beginning of the day by Mr. Lowe, what you've described as the Pretorius letter.
Yes, Chair. So that was the letter that arrived in the offices of Mr. Muyani, which was then handed by Mr. Muyani's office to Mr. Lowe to hand to me. It was that letter that the Hawks all of a sudden now wanted back, but they said that I can have a copy of that letter in return. Now, to make a long story short, and we can go to that, it later turned out that in my copy of the letter, at the bottom of it was attached emails, sort of an email. The email trail that originated at the NPA, went to the Hawks, then went to a lawyer of SARS, and then went to Mr. Muyani's office. But on there, a copy of the letter, that email was not attached. So obviously they were trying to get the emails out of my hand, and that's why they wanted a copy of the letter, which happened to have those emails attached, and they would hand me back their letter where the emails are then not attached.
The one you had, was it the original letter as opposed to a copy, or was it
Mine
also
was
a copy?
the original one.
Was
Well,
the
it was
original?
sent by email and it was printed out.
Yeah, okay. Mm.
So now, how I realized that was that during the discussion, and I must mention then that Mr. Titi then didn't allow me to exit the room. He actually blocked the room, and there was no way that I can exit. I asked for my yes, Chair.
Was this at SARS offices? Was
Yes,
this
Chair.
at Hawks at the Hawks offices?
No, a SARS office.
offices.
It's my boardroom.
Your boardroom?
Yes.
And you were meeting there with the Hawks?
Yes, Chair.
And Mr. Kitty joined them?
Yes, Chair.
Yes.
And I
Now
thought he
you-
was
you
another
were-
member of the Hawks, but he was actually the bodyguard of Mr. Moyane,
Yes,
sent by Mr. Moyane for a particular reason.
yes. And did you want to leave because you were done with whatever business you had with them at the boardroom, or you wanted to leave because of these demands for this letter?
Yes, Chair. So it was very unusual. It never, so for me, I just simply didn't understand what is now going on. And I just wanted to terminate the meeting, exit the meeting, go and do my affidavit, hand that to Mr. Lowe rather than the Hawks, but they didn't want me out. So they did not let me out. And they said that they will let me go if I hand over that letter of the NPA to them, and in return they would hand their letter to me. As this was developing, Brigadier Kaba at a point said, but it's actually the emails that we're after. Then I realized there's something else now going on. And as it happened to be, I was making a video of this whole thing. And when he referred me to the set of emails, I then turned to the emails, and the video was doing it. And afterwards, again, to make a long story short, there was an email that very clearly the Hawks and Mr. Moyane had an interest to retrieve.
At the time when they were making this demand for you to return that email, were you aware of what you have told me, that at the bottom of it you could tell that there were other emails, or you
It was,
didn't know
I
that at
only
that time?
really became aware of the fact that there were these emails when the brigadier said to me, he actually wants the mails that is at the bottom. But even at that point, while I read the mails, just sort of when he referred me to the mails, I didn't really understand what was in the mail. It was only later when I went through my own videos that evening and the day after that and so on, that I actually realized here's a mail from SARS lawyers to Mr. Moyane.
So in your mind, as you refused to hand over the email, what was your reason at that time? I'm asking because
sure.
Ordinarily one would think it would be easy if it was to say, okay, you're giving me the same thing, maybe it's not a big deal. Okay, but if you have some suspicions, obviously, could be different.
No, Chair, it was all about how we are brought up in SARS. If a document is handed to you, to me as a SARS official, I am the custodian of that document.
Yes.
There are secrecy laws.
Yes.
And so
You must
don't
look
have-
after it.
Yes, so
You are responsible for it. So if a document is given to you,
it is
you are trained to say it's your document.
It is my
if
document.
anything happens to it, you are responsible.
Yes, I'm accountable for
You are
that
accountable
document.
for it, yeah.
And now what I did know is that Mr. Lowe said to me that letter was handed to him by Mr. Moyane's office, so that even makes it
More serious.
more serious. So why did? And then that was actually the main reason. The second reason was that I've learned over years that if I don't understand something 100%, I don't make a decision until I understand
Yes,
something 100%,
Okay.
because then I'll make the wrong decision.
yes.
And then a third, to me, was just handing over a letter and getting the very same letter back was also, of course,
Was suspicious.
yes.
Mr. Franklin.
Thank you. You say you videoed the document. What did you use to do that?
A cell phone, Chair.
And did you video each page of the document?
I videoed each a page of the emails. Yes. Yes, Chair.
Thank you. Did you at any stage call anyone from within the boardroom once you had been prevented from leaving?
Yes, Chair. So there was a moment when I really thought this is not going to turn out good. There were 4 huge men of the Hawks, and they were not letting me out. And so I called the SAP's emergency number, 10111, if I remember correctly. And I called them, and that, of course, was a disaster on its own, because they simply could not understand why I would be able to phone while being held hostage, you know. And I also called but before that, I called my secretary, and I also called the security of the building that I'm in. And I mentioned to them, look, you know, I'm being held here, you must now help me. So they duly arrived, and they wanted to open the door, but the door was then closed again by Mr. Titi. So they were not left inside, and I was not able to exit.
Eventually, you did leave the boardroom at some point.
Yes, Chair.
And can you describe what happened when you left the boardroom? At that point, did you still have I'll call it the Pretorius letters, which is the letter plus the annexes, did you still have possession of that?
Yes, Chair. I did. So there was a moment when Mr. Lowe, Mr. Titi was actually on the phone, and that we learned afterwards, with Mr. Moyani during the whole incident. And at one point, apparently Mr. Moyani gave Mr. Lowe a call to come over to the boardroom and diffuse whatever is going on there. So Mr. Lowe arrived. He also brought along 2 other colleagues of mine. And we started to have, Mr. Lowe then asked the Hawks to exit the room so that he can have, you know, to talk to me. And the Hawks did, so they exited. Mr. Titi remained, and so we had a discussion. I explained to Mr. Lowe what is going on in my mind. I also explained to him that, you know, I haven't done this affidavit. The NPA is now waiting for this affidavit, and that I need to finish it. And then Mr. Lowe asked the Hawks if I can make a copy of that letter so that I can, you know, and then they can have what they want. And I said, yes, you're most welcome. But then the Hawks said, no, they're not going to make a copy of it. So, and then there was the moment where I just thought to myself, well, I'm now, since the Hawks is out, Mr. Titi in a way sort of moved to the side, and I suspect that would be because Mr. Lowe was now there. And so I attempted to exit the door. But as I exited the room, there were the hawks. And they then physically grabbed me in the hand, took those documents out of my hand, and off they went.
All right, you've explained to the chair that at the time you received the Dr. Pretorius letter, you weren't particularly aware of what the annexures were, and you've also explained that at a point in time when you were told by the Hawks that they were after the annexure, you looked at it, but it didn't have any particular significance for you. Is
Yes,
that correct? Subsequently, did you have occasion to examine the annexure in further detail? And did you establish why it is that there was this urgent need by the Hawks and Mr. Titi to retrieve that document?
So, Chair, yes, at that point, we could read the words and understand that there is something there, and maybe we should...
Yes, let me take you to the document. It's at page 277, VS 17. You have that?
Yes, Chair.
Is that the annexure that you have been talking about?
Yes, Chair.
That is, there are two emails there. The bottom email is Brigadier Kaba to the attorney Makakela.
Mapakela.
Yes, there's an email address there, sorry.
Yes.
And then what he says, what the Brigadier says, please read that request from NPA and revert to me. We need that statement as a matter of urgency. And then at the top of the page, David Makakela writes an email to Mr. Moyani and to Tebogo Mokwena. And it says the following: kindly find this for your urgent attention. On ethical reasons, I cannot be involved in this one as I hold a different view to the one pursued by the NPA and the Hawks. So can you explain
Yes,
to
Chair.
the Chair what you established, having had an occasion to examine the annexure and to consider it?
Yes, Chair, but these were almost years apart. So initially, back in 2016, this was the wording that we could see. We knew there was something there because why would a SARS lawyer say to the commissioner on ethical reasons, I cannot be involved in this one as I hold a different view to the one pursued by the NPA and the Hawks. Now, this matter related to the early retirement of Mr. Ivan Pillay.
Right, could you just identify for the Chair, you say a SARS lawyer?
Is Mr. David Makapela of M4 Marciani Moodley Attorneys.
A practicing attorney?
Yes, Chair.
Yes, so just explain again. I'm sorry, you said why would a SARS lawyer, when you talk of him as a SARS lawyer, is he an attorney who...
Representing SARS in this, in I think the Rogi unit matter.
All right, can you then explain again? I cut you short.
No, sure. So that is all that we knew at that point, that there was something there, Chair. But it was only much later, in April, around April 2018, about a month after Mr. Moyani was suspended as a commissioner, and we had an acting commissioner at that point, Mr. Mark Kingan, and he and Mr. Wayne Broughton, who's also a SARS employee, had an interview with Mr. Mapakela, and Wayne then went about on a, and asked Mr. Mapakela, what is this mail? What is this mail all about? Why did you say to the commissioner that on ethical reasons I cannot be involved in this one? And Mr. Mapakela then revealed that he wrote a legal opinion to Mr. Moyani in November 2014, when SARS wanted to know from him his view on the lawfulness of the early retirement of Mr. Ivan Pillay. And so he wrote a lengthy memorandum on it and advised that there's nothing unlawful about those elements which I listed in my memorandum, and it happened to be the same that they asked of him. And that was the very first time that we became aware of this memorandum from Mr. Mapakela, which supported the outcome of my 2009 memorandum. And the relevance of this is that not only was my memorandum not revealed officially by SARS to the Hawks or the NPA, but this memorandum from Mr. Mapakela confirming the lawfulness of Mr. Pillay's early retirement was also not made available, apparently, to either the Hawks or the NPA, or both.
Could I ask you please to look at VS 18, page 278 to 291?
Yes, Chair. That is the opinion.
That is the opinion that you've been referring to. It's
Yeah.
dated 5 November 2014.
Yes,
So you say that was rendered on that date to Mr. Moyani, is that as you understand?
yes, Chair.
And then just going back to the VS 17 on page 277, where Mr. Makakela says, on ethical reasons, I cannot be involved in this one as I hold a different view to the one pursued by the NPA and the Hawks. What view do you understand him to be talking about?
It is this view that he expressed, Chair, in his November 2014 legal opinion.
And when he says, I hold a different one to that pursued by the NPA and the Hawks, what were the NPA and the Hawks pursuing?
Well, the NPA and the Hawks were on their way to a charge, Ivan and a number of other people, and he, in his view, it was a lawful action that was taken by SARS.
And when he says, I cannot be involved in this one, do you understand what is he declining to become involved in?
I think it is this matter vis-à-vis the so-called Rogi unit matter. So he was involved, is my understanding, representing SARS to some extent in what was referred to as the Rogi unit matter. And he was then also asked to be involved to represent SARS in this Ivan Pillay early retirement. And I think that's what he means by this. What he means by ethical, if you would allow me to elaborate, is, and this is in his words conveyed to Mr. Kingen and Wayne Broughton when they met, is that Mr. Mapakela mentioned that he shared his view about the lawfulness of the early retirement. Now, not necessarily this document, but his view to both the NPA and the Hawks in a meeting. And that's his, that's my understanding of his explanation why he used the word ethical.
Right, we'll come back to that affidavit in due course. So the events of this rather bizarre day took place, and then is it correct that you sent an email on the same day to Messrs. Moyani and Percy Lowe, which we find at VS 10, page 258?
Yes, Chair.
And you recorded the events...
I'm sorry, what page, Mr.?
Sorry, Chair, it's 258.
Okay.
Is this a much shortened version of the story that you've just told about the events of the 18th of October?
Yes, Chair, and yeah, this is a version I wrote on the very same day because I thought I must write these things down when they are in my memory still very, very fresh, not realizing that even years after that, it remained in my memory as if it happened a week ago.
Did you get any response from Mr. Mayani to that email?
No, Chair.
Then would you look, please, at VS 11, which is on page 259. That's another email by you. It's on the subsequent day, the 19th of October 2016. It's to Moyani, Lowe, and Mokwena, and the subject is Ivan Pillay.
Yes, Chair.
It speaks for itself, but I ask you that particular letter, if I could ask you to read, please, from, I'm sorry, it's the one below.
Sure. This is the one that I wrote on the 18th?
The 18th, no, I'm
Yes.
sorry. You've
Are you on the
quoted it.
19th?
Yes, I'm just looking at this.
Sure.
Yes, the second paragraph, you say a couple of things need to happen today.
Yes.
Most importantly, I need to advise the NPA, Turi Pretorius, from whom the NPA letter came, that I was prevented by both the Hawks delegation and a representative from the Commissioner's office from completing the affidavit sought by the NPA. I need to do this to ensure that the NPA is not left with an impression that I was uncooperative. So
Yes.
you saw the need to explain why you had not completed your affidavit, is that correct?
Yes, Chair. And then I went on in the email and asked for guidance, and I mentioned that I will be sending this off to the NPA at about 11:15, but Mr. Moyani or Lowe or anyone is free to
Dispute the facts.
guide me in that regard, and so in response to this mail, I received a call from Mr. Lowe asking me to join him in a meeting with Mr. Moyani, but I didn't get a written response on this one.
All right, that meeting took place on the 20th of October.
Yes, Chair.
You deal with it in paragraph 59. Could you explain to the Chair what transpired at that meeting, and in particular, what was Mr. Moyani's reaction to the events that you had recorded?
Yeah, Chair, so it was actually not a very comfortable meeting. Mr. Moyani expressed regret for what happened, so that's essentially it that happened during that meeting, Chair.
And you say in paragraph 60 that Mr. Moyani gave you an explanation.
Yes.
And can you please tell the Chair what that explanation is?
Mr. Moyani explained, Chair, that he sent his bodyguard, Mr. Atiti, over together with the Hawks to make sure that nobody makes a copy of the NPA letter. Chair.
Did that explanation make sense to you at the time?
Not at all, Chair, because that's not what happened. They actually wanted the document back. They were not, it is not about preventing somebody to make a copy of the letter. What actually happened was that they wanted this letter back.
But what did you understand the purpose of that meeting to have been? The meeting involving yourself, Mr. Moyane and Mr. Low?
Chair, that's difficult. I assumed at that point it was in reaction to the second email which I wrote, which is this one on 259 at the top, to provide me a guidance. So when I got a call from Mr. Lowe, it was before 11:15, and then I decided, okay, I'm going to hold off.
Yeah.
But then, things didn't turn out like that.
But in terms of the content of the discussion at that meeting, Mr. Moyane, you say, expressed regret at what had happened. Was that the previous day? Yeah, that would have been the previous day, I think.
We're talking about 2 days ago, yeah.
Or about 2 days before that.
Yeah.
And did Mr. Lowe say anything? Did you say anything in that meeting in connection with the
I
events?
just expressed my surprise, and I expressed my views about SARS values and things like that, because it was just a bizarre event. It was, and that was about it. There was no real a purpose for the meeting apart from what was said.
Did you get any understanding of who it was that Mr. Moyane thought might want to make a copy of the affidavit, of the letter that he didn't want to make a copy?
Well, Chair, no. And what is somewhat weird about it is that I had that letter since the morning,
Yes.
sitting on my own in my office with a copy machine readily available. So if I wanted to make copies of that letter, and maybe the thought was that for, I don't know, distribution to the media or something like that, I could have done it.
But basically, his bodyguard didn't say to you, I'm here to make sure that nobody makes a copy of the letter that is with you.
No.
He didn't say that.
No, he actually wanted the letter.
He wanted the letter.
Yes. And when he asked for the letter, he didn't offer me another version or the same version in return. He just wanted the letter and revert back to Mr. Moyane's office.
Okay, Mr. Franklin.
Thank you. And at the meeting on the 20th of October with Mr. Moyane, you said that he expressed regret. What did he express regret about?
Well, he said about what happened to me.
And did he fully understand what had happened? In other words, was he...
I don't know.
Well, did he know, did you tell him, apart from the 2 emails you'd sent previously, did you explain to him what had happened, i.e. you had been kept there against your will and that the documents had been taken from you?
Yes, Chair. So, but it was an overview of what happened, but it was, in even less detail of the emails that I've written to him. So he must have read the emails. So I assume that he knew more or less what sort of happened. But an email which he wrote to me the next day revealed something else.
Before you talk about that something else, do you know whether he would have known in advance or given permission for the Hawks to come and meet with you, Mr. Moyane?
Chair, yes, I think so, because the letter, the NPA letter, was delivered in his email box.
Yes.
So, and it is in that email letter that it is said.
Yeah, so he would have known that they were going to come and see you. Based on that letter, you say?
So I don't think in the letter it is said that the Hawks will visit, but
Yes.
Mr. Lowe said to me that the Hawks will visit.
Yes. So
I'm,
you don't know whether he knew or not in advance?
I would,
Yeah.
no.
And you don't know whether the procedure at the time was that if the Hawks were going to come and interview anybody at SARS, the commission, they would consult the commissioner or speak to the commissioner first. You don't know whether there was such a procedure.
No, Chair.
Okay.
Yes, Mr. Symington, it seems you were not satisfied following the meeting on the 20th of October because you wrote a further email, but I direct your attention to page 262.
Yes, Chair.
That's an email from you on the 21st of October 2016 at 10:32 a.m. to Messrs. Moyani and Lowe, and you thanked the Commissioner for the meeting of yesterday. That's your meeting of the 20th, which you've described.
Yes, Chair.
And you say, I have again reviewed the events of Tuesday this week, and the more I study the records of the events, the more things simply make no sense. With due respect to the Office of the Commissioner, the explanation that Mr. Titi was ordered to ensure that copies are not made of the document containing the request by the Hawks to respond to the NPA's questions is not aligned at all with what actually happened for the following reasons. You then set out your reasons.
Yes, Chair.
And could I ask you to look at point 9 in particular?
Yes, Chair.
What you've said there is, and then even more bizarre, Mr. Titi and the Hawks proceeded to keep me in a confined space against my will and ultimately took the document from me in a manner that, at minimum, was utterly vicious, infringing an endless list of statutory and common law provisions, not to mention my personal rights as both a human being and an employee of SARS.
Yes, Chair.
Mr. Moyani responded to that email.
Yes, Chair.
We see that at page 261. At the bottom of the page, there's an email from Mr. Moyani dated 21 October 2016 to you and Kusi Lowe.
Yes, Chair.
He says in the second paragraph, I still reiterate that my points as per our discussion in the presence of Kusi, it would seem from your mail as if all what I had said does not meet the level of cordiality I expressed, including an apology. You are entitled to the course of action you choose to take.
Yes, Chair.
And then,
I'm sorry, I'm trying to look where you are now,
I'm
Mr.
sorry,
Franklin.
Chair, it's 261.
261.
It's the second email
Oh,
at the bottom of the
I think
page.
I went ahead of you. Oh, yeah, that is Mr. Moyani's response. Is that correct, Mr.
Yes, Chair.
Franklin at 261?
Yes, Chair.
Mr. Franklin,
Thank you.
is that the
Yes,
email you were
that's
reading?
the response.
Okay.
So just to reiterate, at page 262 was Mr. Symington's letter in which he said, I've mulled over the events, I've mulled over the meeting of yesterday on the 20th, and it still makes no sense to me at all. And he sets out the reasons why. And this then is the response from Mr. Moyani to say he still reiterates his points as per the discussion. And he says what I read as a slight rebuke, that you're not recognizing the cordiality that I showed to you.
Yes.
What was your response to this mail? Did it allay your concerns? Did it provide any explanations for you?
Well, Chair, well, no, not at all. So I responded the next day in a last response. I think that was the very last time ever that we had any sort of email correspondence. So at the top of that very same page, 261 is my response to his email, which you will find at the bottom of that page. Yeah, it wasn't the next day, it was the same day, just a bit later.
So just to go back to a question I asked earlier on, the NPA letter or Dr. Pretoria's letter was addressed to Brigadier Klaba
Yes,
and
Chair.
not to Mr. Tom Muyane,
No.
not to Sam. So it would have been Brigadier Klaba, I assume, who sent it to Mr. Muyane. I thought earlier on when you spoke, I thought the NPA had written directly to Mr. Muyane,
No. So the
So-
NPA wrote to the Hawks,
to the Brigadier,
and the
Brigadier
Hawks
Klaba,
then asked the
Commissioner.
attorneys representing SARS to deliver that letter to Mr. Moyani,
Yes.
so that I then can be asked
To do the affidavit.
complete the affidavit.
Yeah. Okay. Okay. So except for the fact that this was, as I understand, an email or copy, the letter actually had been meant for Brigadier Club by Dr. Pretorius.
Yes, Chair.
Yes.
But
yes.
in the letter, it was asked that, and I was mentioned by name,
Yeah.
that I must do the affidavit.
Yeah. Okay, Mr. Franklin.
Thank you. Mr. Symington, could I then just take you to the section of the affidavit in which you deal at page 139 with the apparent importance of the email that was attached to the Pretorius letter. You have given your explanation to the chair, but I'd like to just cover this.
On
What page?
139.
Page 139, paragraph 78. So what you say is that the electronic evidence provided includes video footage of the documents. Just stopping, that's the video you took of the documents while you were being held in the boardroom. Is that correct?
Yes, Chair, I'm just not on the same
Sorry,
page.
paragraph 78, page 139, top
78.
left.
Yes, Chair.
Including the email trail indicating that instead of forwarding the email from Pretorius directly to SARS, Kaba forwarded it to an attorney in private practice who then forwarded it to Moyane with a highly suspicious statement that he could not be involved any further for ethical reasons. So that's the document that we have looked at, VS 17.
Yes, Chair.
And then in 79, you've said that when you received the Pretorius letter from Lowe on the 18th of October, you paid no attention to the single annexure, which at first glance simply looked like a covering email to which the letter was attached. When preparing my affidavit in response to the questions posed in the Pretorius letter, I similarly ignored the annexure. Is that correct?
Yes, Chair, and I must mention that this is normal in a way that if you receive a letter, document, or whatever from the office of the commissioner, there would always be some indication of the origin of the letter. Sometimes it is an email, sometimes it is just the letter itself, whatever. So Mr. Lowe drew my attention to the NPA letter and asked me to do the affidavit. The affidavit.
Right. You then go on in this section of your affidavit to explain that you subsequently learnt more about the circumstances of VS 17 and why it had significance. And you've been through that in relation to the opinion that had been rendered sometime earlier in 2014 rather, by Mr. Makapela to SARS.
Yes.
So as you sit here today, Mr. Symington, what would you say was the reason why the Hawks were insisting that you should give them back that letter?
So, Chair, I think it was the Hawks and Mr. Moyani that had an interest in receiving or retrieving those mails, because the November 2014 legal opinion was not known at that point in time. And the second reason, in hindsight, was what David Mapakela said to Mark and to Wayne, was that he shared his view with both the Hawks and the NPA. So that's why I think they had an interest in making sure that no one sees that mail, because it will lead to questions being asked, because why would an attorney say to his client on ethical reasons, you know?
Okay, Mr. Franklin.
Thank you. You've drawn a conclusion in paragraph 91 at page 144, and you've said, perhaps I should go back to the first, at paragraph 89, page 142. Clearly, the inference can be drawn that at the time Mr. Moyane signed this letter, he was aware that the scope of the initial investigation had been expanded to include the Pillay retirement issue. Now, that's the letter which I took you to a while ago, in which he had given permission for you and 3 others to give information to the Hawks. You recall that?
Yes, Chair.
And you've drawn conclusions as to the relevance of Mr. Moyane being aware that the scope of the investigation under that case number had been expanded to include the Pillay retirement issue. And then at paragraph 91 you say, secondly, Moyane withheld critical evidence, including exculpatory evidence from the Hawks and or the NPA relating to the criminal charges against Gordhan, Magashula and Pillay. Now, what crucial exculpatory evidence are you talking about?
So, Chair, I'm referring there to my memorandum of 2009 and then the legal opinion from David Mapakela. And, Chair, if I may, the reason I'm saying that, first of all, is that the memorandum of 2009, my memo, was available, as I've said earlier, to Mr. Moyane on Mr. Pillay's HR file, which was held in his office. And Mr. Moyane was also aware of the of David Mapakela's legal opinion of November 2014.
Right. I took you earlier to the letter from the NPA to Mr. Moyane, in which he was invited to make representations as to why the charges should not be withdrawn, should be withdrawn. I can't remember which way around. Mr. Moyane then responded to Mr. Abrams in VS 23, page 302. Please, would you turn to that?
302.
302. You see, that's a letter dated the 19th of October 2016 from Mr. Moyane to Advocate Abrams.
This is from Advocate Abrams to Mr.
Sorry,
Moyane.
page 302.
Yes, I am on 302.
So that's from Mr. Moyane to Advocate Abrams.
Yes.
Sorry, it's been a long day. He says, I acknowledge receipt of your letter. And then he says, upon perusal of its contents, I have no further submissions or representations to make on the matter. I am, however, indebted to the decisions of your office and the NPA. So
Yes, Chair. And this would have been this would have been another opportunity for Mr. Moyane to reveal what he knows about my memorandum and about the legal opinion of David Mapakela of November 2014. Another opportunity would have been much earlier when those 27 questions were given to Mr. Gordon in February of that year, because that was widespread news. SARS has a news service where the main highlights of whatever is reported in the media relating to SARS matters mostly, but it would have included this one, is circulated amongst the executives each day. So even if he missed it on main media streams, he would have known about it. And that would have been an opportunity to say to the Hawks or the NPA, look, here's information that they that Mr. Gordon relied upon back in March 2009. Well, a little bit later, but here's the information. So there was ample opportunity for Mr. Moyane to hand over these views.
All right, you also testified about a meeting which had been held between Attorney Makakela with Mr. Kingon and Mr. Broughton in April of 2018.
Yes, Chair.
Could you look at paragraph 95, page 147 of your affidavit? There you say that on that date, Makapela met with Kingon and Wayne Broughton, a senior SARS legal official. He explained that he had provided Moyane with his opinion on the Pillay retirement matter in November 2014, where he had expressed the view that Pillay's request was lawful. In the circumstances, he was concerned about the legitimacy of the investigation into and proffering of charges against Gordon et al. In 2016. Victoria's question on 17 October 2016, Makapela was of the view that it would be unethical of him to be involved in the matter, and this informed his comments to Moyane when he forwarded Taba's email to him. Is that correct?
Yes, Chair.
And where did you get this information from about that meeting and what was said in the meeting?
So, Chair, there are two supporting affidavits, one from Mr. Mark Kingon and one from Mr. Wayne Broughton, and I hope Mr. Franklin would be able to indicate where they are.
Yes, I will take you to those in due course when I put some of the other affidavits to you.
Thank you.
Following upon this incident back to 2016 now, you reported this to IPID,
Yes.
the Independent Police Investigation Directorate, is that correct?
Yes, Chair.
And that is VS 29, which is part of the papers. We need not go to that. Did you set out a full account of what had happened?
Yes, Chair.
And what did you wish to happen as a consequence of your complaint?
So, Chair, I wanted an investigation at least, or charges be brought against the Hawks for the way that they dealt with me on that day.
Yes, and while I see this, perhaps it is best to deal with it now. VS 27, page 308. This is a letter which Attorney Makapela wrote to Judge Nugent during the Nugent Commission of Inquiry hearings, dated the 16th of July 2018. And he sets out there what his various concerns were with the criminal investigation into the Pillay Pension Fund matter. Is that correct?
Yes, Chair.
And in 1.1 he says, firstly, he had advised SARS through an opinion dated 5 November 2014 that SARS acted lawfully with regard to the decision surrounding Mr. Pillay's pension benefits. Correct?
Yes, Chair.
And then in 1.2, ESC says, although Advocate Brassey ESC had provided an opinion or memorandum dated 11 November 2014 that differed with my opinion, I differed fundamentally with Brassey ESC's opinion or memorandum on the question of Mr. Pillow's pension fund benefits. To this day, I still maintain, expressed in my opinion dated 5 November 2014, it would be unethical for me to assist the SARS in an investigation that has no legal basis, even at prima facie level. The important part is that since 5 November 2014, the Commissioner was aware of my views.
Yes, Chair.
You've seen that letter. All right, so apart from your reporting of the incident to IPID, you also launched a grievance against Mr. Titi.
Yes, Chair.
This is dealt with in para 118, page 158 and following of your affidavit.
Yeah.
Your grievance is attached as VS 38. And that appears at page 382, is that right?
(382), you said. 382. Sorry, Mr. Franklin, which page?
382.
Yes. Yes, Chair.
That investigation was, sorry, that grievance was then investigated,
Yes, Chair.
and that was investigated by Mr. Motle, Mr. Tipa Motle
Yes, Chair.
of Motle Juma Sabdia attorneys, correct?
Yes, Chair.
And is it correct that Mr. Motle produced a report on the 11th of May 2017?
Yes, Chair. The report was actually dated 31st of March of that year, but it was, I think, handed to myself or SARS on the 11th of May.
All right, please would you turn to page 397 to page 434. Is that the so-called first report
Yes.
that was compiled?
Chair. Yes, Chair.
Could you summarize what the findings of the investigation were briefly, and then we'll...
Yes, Chair. It was the report found that my grievance was valid and that Mr. Atiti should be, that this matter should go to a hearing.
Did it go to a hearing?
No, Chair.
Is it correct that an addendum report was subsequently produced by the same attorney, and that addendum report is VS 45 of the papers? Is that correct?
Yes, Chair.
You've dealt with this in paragraph 131 of your statement. You say that you heard nothing further on the issue until 25 July 2017, when Rapolo sent an email to myself and Titi, to which was attached an addendum report from Motle.
Yes, Chair, that is right. But what we should add is that I also received a mail from Mr. What's his name at SARS? I will get to the name now. That said that I should not. I think it was on the a day that the first report was handed over to me, it was explained to me that the matter, that there would be a meeting of the parties and that I should reserve any input or comment that I have in relation to this first report. And that never happened. The next thing I heard was a mail also from SARS saying that that the report has been referred back to the attorneys, back to Mr. Moffley, to make a final recommendations, and which I assumed would have been recommendations on the charges that should be filed against Mr. Titi. So I didn't pay much attention. There was nothing found against me in the first report at all, so I had no concern. And then the next email that I got in relation to this matter is the mail that Mr. Franklin is referring to in July. Mr. Franklin, if I'm right.
Thank you. And VS 45 on page 436 is an email from Rapolo to you and to Mr. Titi, dated the 25th of July 2017. And Ms. Rapolo says the following. I had indicated in my mails to you that that Tipe Motle of Motle Juma Sabdia was requested to provide a conclusive report on all findings related to the incident that gave rise to the grievance. He has now concluded that exercise and has provided his addendum report with recommendations to the organization. A copy of the addendum report is attached. The report has been considered by the organization, which is elected to accept the findings and recommendations made. Key amongst the recommendations made was that charges be brought against both of you for possible misconducts highlighted in the report. Due to the dynamics involved in this matter, it has been decided that the disciplinary process be run by external parties. An external chairperson as well as external initiator will be appointed to conduct the process. Details of the proceedings will be shared with you by your HRBP once the parties are appointed. What was your reaction to that news?
So, Chair, I was very surprised to hear that on the very same, well, number one, that there was now a second report by the same investigator on the same facts that have now not only reversed the findings on Mr. Titi, but recommended 4 charges, disciplinary charges, all of whom would have led to my immediate dismissal. None of them are that you get a final letter of demand and so on. All of them would have led to immediate dismissal of me.
Could I ask you to look at paragraph 135, page 163? There you've reached a conclusion in your affidavit.
We're back to his affidavit.
Yes, Chair, it's paragraph 135 at page 163. You say that clearly persons at SARS instructed Mortley to come up with charges against me after the first report exonerated me and concluded that there was merit to my grievance against Titi and that he should face disciplinary action. What caused you to reach that conclusion?
Well, Chair, there was who else but SARS would have gone back to Mr. Moffley to ask for what it was clearly a different outcome.
Then please look at para 146 at page 166. You say that your suspicions were later confirmed when, during about April 2018, after Moyani's departure, Motley was called to a meeting with SARS and asked to explain the circumstances giving rise to his addendum report. At the meeting, attended by Kingan and others on behalf of SARS, Motley started that after he had issued the first report, which exonerated me, he received a visit from Mokoena and Lobello, who pressurized him into changing his report so as to implicate me in misconduct. Motley duly buckled under pressure and issued the addendum report. Kingham informed me of the above facts. So is that something, as you say here, that Mr. Kingham reported to you?
Yes, Chair. But of course, as you know, it later it turned out that it wasn't in April 2018 that the meeting took place, and the meeting took place at the offices of SARS. Which is not the same meeting, of course. But,
Yes, thank you. Chair, I am aware, as regards the Commission's arrangements, that an evening session is due to start shortly.
Yes.
What I have left with Mr. Symington we can deal with fairly shortly tomorrow morning, if that's in order. There are a number of affidavits that I wish to put to him, and I need to collect all those
Yes.
files.
Well, you still have about 30 minutes, if that will be enough. But you have been on your feet since morning, and yesterday you were on your feet for a long time. If you prefer that we stop here and he finishes tomorrow, that would be fine as well.
Yes, I'm assuming that that's in order from Mr.
everybody.
Symington and his representatives.
Yes.
From the nods,
I think all of us who are seated will say that's in order.
I'm relieved. Thank you. Thank you, Chair.
Yes. So you will continue with him tomorrow to finish off?
Yes, that's correct. And Chair, may I just at this juncture, with an eye on tomorrow's proceedings,
Yes, yes.
refer to a letter which we made available to the Chair at
Yes.
lunchtime.
Yes.
As you know, we still have Mr. van Lochrenberg to lead, and the schedule was that he would be led today, and then tomorrow Mr. Moyani would present himself in order to be questioned. The Commission received a letter today, as I understand it, following upon earlier indications, and perhaps I can just read it
Yes.
to the
Into
Chair.
the record, yeah.
It's from Mabuza Attorneys. It is dated the Tuesday, the 24th of March, 2021, and it is addressed to Professor Musala of the Commission, and the subject is T.S. Moyani. 1, as indicated yesterday by our counsel to Advocate Franklin SC and Advocate LaRue, our client, Mr. Moyani, is suffering from a serious illness. 2, he will accordingly, unfortunately, not be in a position to prepare for and appear before the Commission as previously agreed. 3, we attach here with a copy of the doctor's note for your attention. 4, we look forward to hearing from you so that any alternative arrangements may be discussed and agreed. 5, kindly advise the Commission chairperson and any interested parties accordingly. And then a doctor's note is attached. So
Yes,
it
okay.
appears that Mr. Moyani is unable to appear at this
To
point.
appear tomorrow.
We will make practical arrangements in due course, but I thought I'd better just let that be known at this
Yeah.
point.
Yes. No, that's fine. But effectively, your plans will now be to use tomorrow to finish off Mr. Symington's evidence, as well as to begin and lead Mr. Lochrenberg's evidence.
That is correct.
Yes. Okay. No, that's fine. I am aware of the letter, as you said you did show it to me. So Mr. Moyana is not able to appear tomorrow. Okay. I'm going to adjourn the day session of the hearing. The evidence leader for the next work stream, ESCOM, is he here? Okay, he's here. So we'll take about a 15 minutes adjournment to enable them to set up. And then Mr. Symington, you will be back tomorrow. Let's start at 10 tomorrow. I think the past 2 days we have been starting at 9:30. So we'll be back here tomorrow at 10.
Yes.
Okay.
Thank you, Chair, and I take it we're excused from the evening session, which deals with something different.
Yes, definitely. You're excused. You need some rest.
Thank you, Chair.
We adjourn.
Dr. O, are you there? Evening, afternoon.
Can hear you.
You wait there? Cool, cool. We're waiting for the
Alright.
witness to join, okay? I think.
Well,
Cool. Camera one, give me chairperson's chair. Camera one. Chairperson's chair, thank you.
SABC hearings been
Ms. Daniels, are you there?
case isn't in yet.
I see any witness, don't worry.
Wrong witness.
Ms. Daniels, are you there?
Yep, Brev, I'm here. I need this, to go on so you can see.
Timbos, adjust the laptop to the monitor for the witness. Oh, good. Adjust the laptop. Oh. Good afternoon, Ms. Daniels, how are you? Please unmute. Can you hear us?
I am unmuted.
Much better.
Oh.
We can hear you now, yes.
Oh,
All right. How are you?
I'm tired.
Same here. Can you see the gentleman on the green chair?
I can see the gentleman on the green chair. Yes.
Okay, that's fine. We will start shortly. We're just waiting for the GCG to come. Just testing quickly. SC,
Okay.
Mr. Slega. Mr. Slega, will you please test your mic, please? Yes, please. Just sanitized that already. I did that. You can do that again. Yes, I did.
Yes, Suzanne, Ms. Daniels?
Hello.
Okay, you can hear me and you can see me.
I can't see you.
You can hear me.
Yeah,
I can hear you.
yeah. This will see you.
This sound is very good, guys. Don't change my sound. Please don't change my sound. This is a very good
Yes,
sound.
please. It's much better than the last time.
Thank you. We're ready for the day. Thank you so much. We'll let you know when we start. Thank you.
Ms. Daniels?
Ms. Daniels? Ms. Daniels?
Yes. Hello.
Yeah, we want to start. Which bundle are you using? Ms. Daniels, which bundle are you using?
ESCOM 14 for the CDH.
Okay.
Good afternoon, Mr. Slager. Good afternoon, everybody.
Good evening, Chair.
You don't sound vigorous, Mr. Slager, this morning, this afternoon. You sound like you have been standing the whole day.
Yeah.
Are you full of oomph?
It will come, Chair.
It will come.
I'm sure it will come.
Okay, all right. Good afternoon, Ms. Daniels.
Good afternoon, Mr. Chairman.
Thank you once again for availing yourself. Hopefully, today is the last time.
Yes, I hope so too.
I see Mr. Slager also nods. So hopefully today is the last time. Okay, all right. How much time has lapsed since she was testifying?
I think about 2 weeks.
Oh, didn't she testify last week?
No, not last
anyway,
week.
okay. Registrar,
I'm not
please-
sure, Mr.
please
Chairman.
administer the oath of affirmation. Well, it's been so many times, we all can't remember.
That's right.
Please state your full names for the record.
Suzanne Margaret Daniels.
Do you have any objection to taking the prescribed oath?
No.
Do you consider the oath binding on your conscience?
Yes.
Do you solemnly swear that the evidence you will give will be the truth, the whole truth, and nothing but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you.
Thank you, Chair.
Okay, you might, obviously, Mr. Slager, wish to remind the public where we are with Ms. Daniels' evidence and what remains to be covered.
Yes, Chair. Thank you. Ms. Daniels is specifically back today to cover the issue regarding the penalties, which is the penalties claim of 2.17 billion rand that Eskom intended pursuing against Glencore OCM. That penalty amount was ultimately settled with Tegeta after it had taken over OCM at an amount that was significantly low, much lower than what had originally been the claim. She has dealt with other aspects of her evidence, and we had adjourned. We couldn't finish the penalties, we adjourned her for this specific purpose. There will be, so that's the main focus for today. There will be an aspect that she has to clarify to the chairperson in relation to McKinsey. Those questions were put to her last time, and she answered in a particular way. She wishes to clarify her answers, and we will give her the opportunity to do so at the end. Now, on your appearance, Ms. Daniels, the last time, well, the penultimate time, so the second last time, we traversed the issues of the penalties looking at the first opinion that CDH had given to Eskom. And Chair, for the purposes of reference, we will specifically refer to Eskom Bundle 14, and the documents have now been moved to bracket D of Eskom Bundle 14. Ms. Daniels, on your side, you are using the soft copy. The documentation are not marked as in the hard copy. So for your purposes, we will simply refer to the page numbers. And just to recap, Chairperson, let's go to that Eskom Bundle 14 bracket D. The bundle contains an affidavit of Mr. Rishabhan Mutli, an attorney from Cliff Decker Meyer.
Yes, I've got it.
Yes. And on page 984, page 984 was the first opinion memorandum dated 23 October 2013, which we traversed in the second last appearance of Ms. Daniels. Ms. Daniels, we were about to go to the second opinion of CDH. And Chair, what we hope to achieve with her evidence is for Ms. Daniels to show you the various concerns that were raised. When were they raised? Where are they contained? And whether the concerns were the same throughout. Thank you, Chair. Ms. Daniels?
Okay.
You can hear and see us.
I can hear and I can see you, but I can't see the
Okay.
chairman. Oh, there I can. Okay.
Yeah.
Okay.
All right.
So,
Mr. Chair,
yes.
so
Yes, Ms. Daniels.
with Mr. Seleka's permission, I'm going to do it a little differently. I'm going to start with where I got involved and then work backwards and show you in the previous opinions where the themes are the same, if that's in order.
You say work backwards. I don't like working backwards, generally speaking.
Ooh, okay.
But you may not be meaning working backwards. As I understand it, you first want to testify about the role you played and then go to the opinions. Is that correct? Is that what you mean? Rather than start with the opinions.
That's correct. So that I have a point of reference for you.
Yes,
You know,
yeah, you see.
it makes it easier for me.
That's not working backwards for me because your role, the role you played came first, isn't it? And the opinions came
Yes,
later. And the opinions came later, or was it not?
Yes, and then there were opinions in existence already, Mr. Chair.
When you came,
that was the
got involved.
23rd when I came in.
Yeah, okay. I don't know what Mr. Selega has in mind, but if for me, you start with what you got involved in before we go to opinions, that's fine with me. If he feels differently for his plans, I'm easy.
Chair, her timing of involvement comes somewhere in the middle.
Quite in the middle.
Yeah.
So you wanted to go according to what happened when.
That's right.
And if opinions came before she got involved,
yes,
you wanted to deal with those opinions.
Correct.
And when you get to where she got involved, you wanted to make sure that that's in accordance with the sequence of events
That's right.
as they evolved at that time, as they unfolded at that time.
That's right.
Do you have some difficulty with that, Ms. Daniels?
No, Mr. Chair. I will make it. I will fit in with that. It's just. It will make it.
You might not have much to say, I assume, about opinions that were given without your involvement and before you got involved.
Well, what I can do is I can confirm for you that I have read them.
Yeah.
You know, I was provided with them when I did get involved.
Yeah.
And I can, at least from that point of view, give you insight into what they contain.
Yes, but from your point of view, it would be much more convenient to start with what your role was and then look at the opinions. That's what you preferred.
Well, it was just from a point of referencing the documentation, because essentially, Mr. Chair, the opinion didn't change from 2013 to when I got involved.
Okay.
From a substantive legal point of view.
Yes, I leave it to Mr. Selega. You've heard what she would prefer, but she has said she can work with your plan as well.
Yeah.
I'll leave it to you. I'll leave it to the two of you.
She can start with her role, Chair.
Yeah.
I mean, I suppose in the end, we will have a clear picture of the sequence of events, because I had already started leading evidence on the first opinion.
Yeah.
But Ms. Daniels, if you prefer to explain to the chairperson first and foremost when you got involved, what is it that you did, and what opinions were given to you at that stage, and what opinions you sought and were able to obtain. And then maybe we can go into the sequence of those opinions.
All right, that works.
Okay, firstly, when did you get involved? How does the matter come to you? And what were you expected to do?
Mr. Chair, I took over the role of acting head of legal and compliance in September 2016. And at that stage, Optimum had just come out of business rescue in August. It was one of those litigation matters on the list that Eskom had to contend with. My first point of call was to try and understand what had gone before, because now that Optimum had come out of business rescue, we could continue with the penalty claim, for want of a better description. This would mean that we would be continuing with arbitration proceedings. And I wanted to understand, firstly, the merits of the claim and understand what the issues were that were involved. And it was on that basis that my first request, having seen the documentation, was to ask CDH to undertake an assessment of the claim for me. The reason for doing that was had been a number of changes in the context. Obviously, Optimum had now been taken over by Together as the majority shareholder. Internally, Eskom, the staff members who were involved and who would be the potential witnesses were no longer around, and we needed to assess also the nature of the expert claims. In their opinion, there were once again 3 issues. It was around the contract management. It was around the sampling process, the calculation of the penalty, the interpretation of the penalty clauses, and then obviously the application of the penalty during the periods involved from March 2012 to 2014, and then from June 2014 to May 2015. So in this opinion, the assessment was around is Eskom in a position to refute that it failed to comply with the CSA in the respect of contract management procedures? Did it in fact waive its right to impose the penalties? And the failure to calculate the penalty correctly. So if you then, this is in December 2016, when I get the assessment. But if you go back, and like I testified last time, to the 2013 opinion, which is in bundle 14, my reference page is 984.
What page would that be on mine, Mr. Saleh?
It's the same, Chair.
Oh, okay.
Page 984, ESCOM bundle 14, bracket D.
Yeah, okay.
Mr. Chair, we did go into a bit of detail last time about, you'll recall this, the factual things. But I just wanted to point out to you that once again, in 2013, well, not once again, at the beginning of this story, the credibility of the sampling process was questioned because of the procedure that Eskom followed. At this point, Eskom was already in renegotiation on the sizing parameters of the coal. So that meant that Eskom was already not implementing the sizing penalty. So there's a risk. There was also a risk highlighted that the penalties that Eskom was imposing would be in contravention of the Penalties Act. The attorneys also identified that perhaps given all these factors, there's a risk that the Optimum would cancel the contract. And more fundamentally, there was also the issue that based on all these facts and the failure for Eskom to implement the contract management procedure as set out in the contract, that it had in fact waived its right to impose the penalties. So this was at the start, and you'll remember the last time it was about the, at this point, Eskom was going into detailed negotiations with Glencore to see how they could remedy some of the issues that were that were coming up in terms of managing and operating the coal supply to Hendrina at the time. So that was in 2013.
Yeah. Ms. Daniels, what we identified last time from this memorandum were 3 categories of issues raised by CDH or concerns raised by CDH. The one on page 984 was in respect of coal quality. And then they gave a whole range of concerns relating to coal quality. And on page 986, they dealt with sizing specification. And lastly, on page 988, they dealt with coal quantity. In fact, that's the second last, that's the penultimate. You also had what they refer to as a conveyor availability dispute, which is on page 989. But that relates, that relates to the quantity of coal that was required to be supplied to Eskom.
Well, that was in terms of, that's what I'm saying, in terms of the context, at that time, remember Eskom was going into discussions with Optimum on the entire contract management and operation of the supply to Vendrina from Optimum. So it covered a little bit more operation issues. In respect of the quality, the penalty issues, it would relate to the sizing and the quality parameters. So that is what I highlighted. So the credibility of the sampling process, the sizing specification, and whether Eskom had the right to actually impose those penalties were the key issues. The other issues, just in the context of the memo, you know, was because of what Eskom was going into.
So you would have been given this memorandum at the time when you took over this matter?
Yes, it was part of it was actually part of the assessment of the merits. You'll see that it's annexed to that memo as well, so that I could get a full picture of what the issues were.
Yes. On quality, if you go back to page 984, I wonder whether you could succinctly identify, just by way of recollection, the issues that related to coal quality. Because my recollection on coal quality was that Eskom had failed to raise an objection or notify OCM that the quality of coal was inferior within the timeline specified in the contract. And as a result, they would then have been deemed to have accepted that coal that was delivered was of acceptable quality.
Yes, that is correct, Mr. Chair. I classified that as Eskom's failure to manage the contract in terms of the processes, and that is the detail of the process, that had Eskom not provided those notices in terms of quality, then it in effect lost its right to then claim it at a later stage. You will see from the documentation that there is this, at that stage, there is this sort of reservation of rights. And I think that became a dispute because in terms of the actual contract management, there were no notifications provided to Optimum to say that you have failed to meet this quality specifications and therefore we can impose the penalty. And in terms of the contract itself, if there was no notification that right then fell away and it was deemed, CDH does call it a deeming provision. It was then deemed that Eskom accepted the quality as was provided.
Okay. Mr. Selega, this memorandum
Yes.
that you said we should go to 984
Yes.
is a memorandum by the attorneys?
Correct.
That's their opinion.
Yes.
Does it deal with that particular issue as well? The
The-
issue that you have just raised?
Yes,
About the
that's,
failure to notify, to give notice, in terms of, is it clause 16 of, or is it 26 of the coal supply agreement?
it's in terms of clause 3.6, Chair.
Oh, yeah, 3.6, yeah.
Yes. Yes.
Where does it deal with that issue, this memo?
Let's see.
Oh, I assumed that it dealt with it when I had you. Well, there is, in respect of coal quantity, that's quantity, not quality.
It's they set out, let's see, paragraph paragraph 4 dealing with the penalty and payment rejection provisions. Paragraph 4.1 impose a penalty for abrasiveness. In 4.2 impose a payment reduction or adjustment in terms of clause 3.6 for any coal which fail to comply with either the sizing specification, calorific value, ash content, moisture and volatility on the following sliding scale. So 4.2 will lead us to that, so it gives you what you should do.
4.4 refers to clause 3.6.
Correct.
The nature of the volatiles of coal is that should it exceed the prescribed range contemplated by clause 4.4.1 of part 2 of schedule 1 to the CSA, it is relatively incombustible and of no or little use to Eskom. That being the case, Eskom may want to consider bringing a claim for the rectification of the CSA and addenda in order to ensure that the intention of the parties is correctly portrayed. As the CSA with the first addendum thereto currently stands, Eskom's remedy for coal which does not meet the volatiles quality parameter is limited to the payment reduction contemplated by clause 3.6 of the first addendum. And the other remedies provided, in brackets, specific performance therein, provided that Eskom has evidence of the people who negotiated the first addendum available to prove the common mistake and that the arbitrator shall rectify the common mistake of the parties. What really I was looking for is where they express any opinion, if they do, along the lines of what Ms. Daniels is saying,
Yes.
namely failure to give the notification contemplated in clause 3.6 results in Eskom, would have resulted in Eskom losing any right it might have had to a reduced payment or reduced price.
Yes,
Mr.
correct.
Chairman, may I just
Yes.
assist there? You will find it in paragraph 7.5.
7.5.
There's 5, which is on page 988.
Oh, yes, I see. Eskom has waived its rights to impose and subsequently enforce the payment reduction for certain of the months, OCM failed to supply and deliver coal, which complies with the sizing specification due to ESCOM failure to inform OCM of the payment reduction and calculation thereof timelessly as required by the terms and conditions of the CSA, read with the addenda. Yes, no, that's what I was looking for. But what I want to ask is whether you are aware, as a matter of fact, that ESCOM did not, during the entire relevant period, give such notices as are contemplated by clause 3.6 to OCM? Or is that something you are not sure about?
Mr. Chair, from my experience, it was very sporadic. I was the contract manager in primary energy before I rose through the ranks. I was head of the contract management unit in primary energy, and it was a problem. So there was not just on the optimum contract, but on all the contracts that ESCOM was sporadic in issuing these notices. The detail of when and how, the reason for that is quite, not complicated. From my perspective, there was always a change in staff, the contract managers. So you will see that there were periods when it was done fastidiously, and then there were periods when nothing happened because it was informal relationships with the suppliers. So it is a problem in ESCOM, and in this instance, as at 2016, when one looked back, it was sporadic.
Well, what I'm talking about is, if you look at the period to which ESCOM's claim against OCM related, which I understand would have been from about 2012, Mr.
Yeah.
Of 2012.
March 2012. Yes.
Yeah, March 2012, ultimately, I think to March or April or May 2015, if I'm not mistaken.
May 2015.
May 2015. If you look at that period, while you were at ESCOM, was there occasion for you to say, I want to know, as a matter of fact, whether during this period we do have proof of such notifications as having been sent to OCM, and you got an answer that there were none, or you got an answer that there were some, but not everything, not for the whole period?
There was some, Mr. Chair. There was some in the early stages.
Yes, in the early stages of the period we are talking about.
Of the period that we are talking about.
Do you have a recollection of the sense you had, whether if ESCOM wanted to use those that were available, they would have covered maybe half the period, a quarter of the period, or only a few, 25%, 10% of the entire claim or period? Do you have a sense of how much they would cover in terms of how much of the claim they could be used to prove?
It was a small amount, Mr. Chair, in terms of the contract management. I wouldn't hazard a guess now.
Yeah, but it was a small amount.
It was a small proportion.
Yeah.
And that's why it was a big issue. You will see that it becomes an issue in terms of, it is always the first issue that CDH raises, is that our ability to prove that we had managed in terms of clause 3.6.
Yes. And I guess that in this opinion, I guess CDH would have asked ESCOM, do you have this proof?
Yes,
yes.
and I think Mr. Moodley's affidavit does actually,
Deal with
he
that,
mentions
yeah.
the occasions in which he's asked.
Yes, yes. Now, this memorandum, this opinion is dated 23 October 2013, which is rather early in the period. When this would have been less than a year before Mr. Molefe. No, this would have been less than 2 years before Mr. Molefe came to ESCOM, because he came in April 2015.
15.
Yeah, 2015. Do you know whether that there was this problem about this claim of ESCOMs against OCM was brought to his attention?
Yes, it was, Mr. Chair. I can confirm that I was in one meeting with Advocate Solanko, who was head of legal at the time, and Mr. Moodley.
Advocate who?
Solanko, Nayo Solanko.
Sonako.
Solanku.
Oh, okay. I can think, give the spelling, Mr. Seleka.
Yeah, it's TSHOLANKU.
Okay. So you were in a meeting with him and with who else?
With Mr. Moodley from CDH,
Yes.
Mr. Molefe,
Yeah.
and Mr. Koko was there
Yeah.
as well. And they were explaining to Mr. Molefe and Mr. Koko the issues that we had.
Mm. And do you have a recollection of when that would have been, not necessarily the date, but when in relation to April 2015, when Mr. Molefe came to ESCOM? And would it have been 2015 or 2016, or is there something you are not able to remember?
I'm not able to remember, but I can give you context because Mr. Molefe and Mr. Koko were going into meetings with Optimum.
Yes.
And Mr. What's his name? Mr. Efron.
Yes.
You know, so it was round about that period. And they were taking them through that these are the issues involved.
And what was said about ESCOM's claim against OCM in regards to in that meeting?
There was always the issue, Mr. Chair, of how would ESCOM prove, you know, the 2.1 billion.
And was there an answer given as to how ESCOM would prove that?
Answer from who, Mr. Chair?
From anybody in the meeting.
Okay. I think the issues were that we were saying be careful. Well, from the legal team, they were saying be careful to say that ESCOM, you know, has a definite claim of 2.1 billion because of these issues that we have.
Yes.
You know, because
yes.
we will not be able to prove 2.1 billion.
Yes.
And the issue got, you know, the issue is essentially application of the sizing. This was a quality penalty issue, to make it simple. So, for example, if you included the sizing, you get a claim of 1.4 billion. If you exclude it, you get a claim of 419 million.
Yeah.
You know?
Yeah.
And then you still have issues. So there's already a problem with proving that the sizing parameter is actually a legitimate penalty claim, because we have started negotiating with these people So in terms of the contract, once you start negotiating, the sizing parameter actually does not apply, so you can't impose the penalty.
Yes.
And then the other issue is you have not imposed the notification process in terms of the contract management. So your ability to claim in respect of the other qualities also falls away. You know, so it was a layered approach. So the caution at that time, both from the legal team and also the operations team, I think I read in Mr. Bester's affidavit at the time that he had also cautioned Mr. Molefe about, you know, using the figure of 2.1 billion because of the problems, is that yes, we have calculated 2.1 billion, but these are the issues that are involved, you know.
If
At
you
best,
continue, I'm sorry, continue.
at best we could claim something, but we need to work out what that something is.
If, as a matter of fact, you had no proof as ESCOM that you had issued these notices in terms of clause 3.6, let us say at all, for the entire period, how much of the claim would that affect? Of the 2.1 billion rand or something, more or less? Or is that too much maths?
Mr. Chairman, may I answer it this way?
Yes.
And then you can tell me if it happens. The 577 that we eventually settled at, you know, knowing the totality of what I know now, I think we were lucky to get to that number.
So your sense is that the failure to give notice as contemplated by clause 3.6 would have affected at least not less than 1.5 billion, maybe even 1.8 billion.
Yes.
Of the 2.1 billion.
Of the 2.1 billion.
Yeah, so a substantial amount, much more than 50%.
Yes.
Okay, all right. Mr. Slegger.
Yes. Thank you, Chair. Ms. Daniels, I think you earlier gave a breakdown of the figures in respect of sizing and quality. Maybe that might answer the chairperson's question. What figure did you give in respect of sizing?
I said if you included, it was about, what did I say, 1.4 billion?
Yeah.
And if you excluded, it was 419 million.
So the 490 million would only relate to quality.
Yeah. In terms of coal language, sizing is also part of quality.
Or sizing is also part of quality.
Yeah. So just please forgive me, but the reason we use sizing separately is because of the provision relating to sizing that was then waived.
So sizing would also be affected by the failure to give notice under clause 3.6.
Yes, Mr. Chairman, but there was an added complication with the sizing parameter, because it said in the contract, and I think it is in 3.6, but it said in the contract that should there be a problem with sizing and the supplier brings it to your notice, then the provisions, then we'd renegotiate the sizing and the penalties would not apply while that renegotiation is happening.
Okay, okay.
So there was, that's why I said there was this added layer of, you know, when you start with this globular figure of 2.1 billion, when you start unpacking it, it gets complicated. And these are the issues that CDH raises in 2013, 2015, and 2016 and 2017.
Yeah.
Okay.
Just quickly on quality, I see, it seems, and you can confirm, that the operative paragraphs in respect of quality was in this memo, 4.4 and paragraph 5. And 4.4 read with 5 refer to that abolishment, they use the word abolishment of Eskom's rights to an outright rejection of payment for coal which fails to comply with the volatile quality parameter. And they say this may well have been an unintended consequence of the amendment of the CSA, which is the supply.
Yes.
That is taken further in paragraph 5 on page 986, where they say, save for the payment reduction contemplated in clause 3.6 of the first addendum and the reduction of the purchase price for the abrasiveness level of coal in terms of the second addendum, all other penalty provisions relating to the failure to meet the quality specification of coal in terms of the CSA have been abolished. The only additional remedy available to Eskom, should OCM fail to supply and deliver the correct quality of coal, is the following. 5.4 is specific performance. 5.1.
One.
Yes. So what they're saying, you can't impose a penalty. You can ask them to comply with the agreement.
Yes, in order for specific performance.
And then 5.2, which is another remedy available to Eskom, they say in terms of clause 3.5 of the first addendum, Eskom may take steps to dry wet coal which exceeds the moisture content limit of 10% of OCM's expense. However, OCM must stop all supply of coal to Eskom in the event that the hourly moisture content, as measured at 2 hourly intervals of coal delivered under the clauses they mentioned, will only continue deliveries when the moisture content per 2 hourly interval is less than 12% alternative. So it seems from the reading of this that Eskom's right to impose a penalty in respect of quality was apparently in the amendment of the CSA taken away.
It was taken away in the sense that it required a far more rigorous contract management approach to apply than before.
Yeah, but CDH is raising this as a concern that it seems when you amended the CSA, you took away your rights to impose a penalty in respect of quality.
Yes.
And they say it may well have been an unintended consequence, if you go back to paragraph 4.4, but they go on to say in that paragraph, you will need people who negotiated that amendment to confirm whether that was the intention of the parties.
That is correct. And the person, the lead negotiator at the time, had already left Eskom. I think I was part of that team, and the other people, I think they had also left Eskom. It was there were very few people who would be able to testify as an expert on we would testify on the intention of the parties, but CDH did say that we would have to go to court to get a rectification of the agreement.
Yeah. But that didn't happen. Go into
No,
court.
that did not happen.
That did not happen. So on my reading of this, tell me if I'm correct, CDH is saying, well, if you are imposing a penalty in respect of quality, it seems to me that you don't have that right because you've taken it away. The only right you have is to tell OCM to comply with the agreement. Ask for specific performance, or you dry the coal that has too much moisture, you bring it down to the level that is acceptable.
In simple terms, yes, Mr. Seleka, I would just add that number one, what CDH was saying is you need to notify them. Okay, if you want to apply the penalties,
Yes.
you need to notify them that you're not happy with the quality, so that the penalty can apply. You need to make sure that you are clear about the sizing requirements, because right now you are negotiating with them and therefore you have waived your right to impose any sizing issue. In respect of the moisture, you need to dry out the coal and charge OCM for that drying out process. And as I told you last time, you need to fix they need to fix the hammer sampler, because that's where the moisture testing was also being done. So in layman's terms, what CDH was telling Eskom is you need to get your house in order if you want to apply this penalty regime as it states. And obviously, fifthly, go to court and get the rectification that you require.
Yes. So that's the first opinion. You have quantity as well, and there's a dispute about the conveyor belt issue. Do you have anything more to say? You were talking about reservation of rights at the end of the opinion.
Sorry, I've lost my place.
It will be page 989.
Can you?
On which page are you?
I'm now on 989.
Yeah, under conclusion.
Yes, I'm just reading it again.
Yeah, they make certain observations there in conclusion.
Yeah, they say that, OCM will just not accept it at face value. The risks identified in respect of the payment. And then if Eskom wants to proceed with the claim, it should not do a set-off, and Eskom should rather demand the payment.
I see paragraph 10. They say, in light of the risks identified in Eskom applying the payment reduction for OCM's failure to comply with the sizing specification at this stage, we advise that it would be prudent to first address all the concerns in order to ensure that Eskom will be in a better position to impose the payment reduction and subsequently enforce any claim for the reduction of the purchase price due to OCM's failure to comply with quality or quantity specification. Now, that sizing specification had to do with that, the hammer you refer to, the hammer sampler that ESCOM was using, which was misaligned and not doing proper sampling. Do you know whether
That's
that was?
correct.
Do you know whether that was ever corrected at the time you were there?
To the best of my knowledge, it was not, Mr. Chairman.
But even if
During,
say again.
during this time, it was not corrected.
But even if corrected, would it affect the situation, the historic situation? Would it have affected the historic situation?
No, it would not have, because of the other issues that this memo identifies.
Yeah.
You know, I mean, the contract did not apply retrospectively.
Yeah. So this,
Oh, I'm sorry, the penalty regime was not retrospective. It was actually contemporaneous.
yeah. So this particular concerns would have been drawn to the attention of the executives you've mentioned, Mr. Molefe, Mr. Koko.
Yes. You will see at the time this memo is addressed to Mr. Jan Bester in primary energy. So both at operational level and then at executive level, people were aware of what the issues were.
Yeah. I recall in your affidavit you do mention that these concerns were also drawn to the attention of Mr. Anoj Singh.
Yes, I just don't recall if it was in, you know, this kind of detail, but I had provided the latest, you know, the ones that I was involved in, those memos to Mr. Singh.
Yeah. Do you want to take us to the second opinion or somewhere else?
I think the second opinion is in March 2015, Mr. Chairman, and that is on page 992 in my bundle. ESCOM bundle 14.
Yes. It is sent to you or to ESCOM by email, which is on page 991.
Yes, the date is incorrect on this one. It says 17 March 2014, but it's in fact 2015.
That's interesting. Why would anyone in March write the previous year? I can understand when it's January, people take time to get used to the new year. But why would anyone in March 2015 still be writing 2014 on the date?
I think you must ask Mr. who wrote this memo.
Why do you say 2014 is wrong? It should be 2015. What's the
I'm
basis
just basing
for that?
it on the fact that the memo is, the covering email is dated 2015, Mr. Chairman, and it's 17 March 2015.
Well,
So I'm just assuming
Chair, there's another
I
way
may
to
be
resolve
wrong.
it.
yeah,
There is another way to look at, to resolve that issue.
yeah.
We will have to go to, since this is an annexure to Mr. Mutli's affidavit,
Yeah.
we'll have to go to his affidavit, which is,
Well, I recently saw a document dated March 2020, and the question arose whether there was a mistake. It was meant to be March 2021. And I said, well, in March 2021, nobody would be confused about which year it was. So looks like I may not be entirely correct. But
Well,
I wouldn't.
Mr.
I just
Chairman-
wouldn't understand it. I mean, in March, you have been, everyone knows this, a quarter of the year gone. Yes. But you were saying, let's look at the affidavit, Mr. Slager.
yes, on page 907,
907.
yes, paragraph 45.5. Yeah.
Yes.
So 45.5, which reads, prior to the lapsing of the cooperation agreement, CDH provided updated legal advice on the penalty claim and related risks on 17 March 2015 to, and then mentions the names, Ayandan Tet, Andrea Williams, Pam Pillay, and other ESCOM officials. See item 17.2 of the bundle. Now that email with the attachment to which is that 17.2, then you will see they're quoting certain portions from that email. I mean, from the document itself, the memorandum which is dated 17 March 2014.
Have you seen anything like that?
Not at all.
Ms. Daniels, have you seen anybody who in March doesn't know which year they are in? They are still thinking of the previous year.
Mr. Chairman, time has become such an issue these days. I'm a little bit more forgiving.
It's like were they sleeping for 3 months?
Then in
anyway.
in paragraph 1, Chair, yeah, this may well be conclusive. Paragraph 1 of that memo reads, we refer to the meeting held.
Oh, I'm sorry. I'm at 984. I should be somewhere else.
Oh.
I'm at the memo that is at 984.
Good.
I should go to another page.
Go to the one 992, Chair.
992.
Yes, that one.
I think I was there and then I find myself back here.
Yeah. That very one with 2014 date.
Yeah.
Maybe
yes.
Yeah, that will help. We refer to the meeting held on 11 March 2015.
Yes. Very strange.
Yeah.
Okay. I will assume that for some reason they thought it was still 2014, but it was 2015. Okay, let's continue.
Yes. Ms. Daniels, yeah. So what do we find in this memo?
Now, Mr. Chairman, I think here, this, once again, the context was that this meeting was asked to explain the penalty provisions in terms of you will see the people, they were coal supply managers, the internal legal team, as to the application of the penalty provisions in the contract, once again. And this is March 2015. I think here CDH is a little bit more emphatic about the fact that ESCOM has not applied the penalty regime for the last 3 years. So that means the period from 2012 to I'm assuming the date of the memo, 2015, that ESCOM actually has not applied the penalty regime. It's here that they talk about those accrued rights, but they also talk that, the figures are still not okay, but they do repeat again the same issues, the interpretation of the clause 3.6. So it has not been rectified at this stage.
If I may, Ms. Daniels, I think as you highlight the points in the memo, you could do so by reference to the paragraph numbers. I see paragraph 4 deals specifically with that first point you mentioned, which is ESCOM's failure to impose payment reductions for approximately 3 years.
Yes. So, you know, it starts off saying Eskom has for approximately 3 years not imposed any payment reduction. So, Mr. Chairman, to answer your previous question, it would then seem that they had looked at the documentation that we had, you know, and
Yes.
come to that conclusion that we actually had not imposed it. And they also, in paragraph 3, talk about this concept of accrued rights, and you will see they put it in inverted commas because of all the issues that they've identified and will continue to identify, you know, as to how one applies that.
Yeah.
That's in paragraph 3 of the memo.
Yeah.
And once again, you will see that the issues are the interpretation of the clause 3.6 in 4.1, the sampling process, the disputes around the sampling process, the negotiation around the sizing component, which is in 4.3, and then there was the hardship dispute, which was raised by Optimum. So there are more issues, you know, added. And then again, you see here is in paragraph 5, they go into more detail. So it gets a little bit more, what's the word, emphatic at this point, where they say, you know, we understand that Eskom has not imposed penalties for sizing for the period from March 2012. And then they set out the reasons why they say that. And then they also say, in order to protect your rights, this is what you need to do.
And
that you see in, I think it's paragraph 5. I'm reading from another screen to make it easier.
yeah. And as I understand, while we're dealing with sizing penalties, the portion of the claim, the 2.17 billion, relating to sizing, was ultimately abandoned, as I understand from the papers.
Yes, you would see that in the last memo where we calculated it. That was the I think it was 1.4 billion.
Yes. We will get to it.
We will get there, but that was the size because of this reason, and this is in 2015 when this was pointed out.
Okay. Any other points you wish to draw to the chairperson's attention?
I think Mr. Chair, it's the same issues again. You know, I think I want you to take note that once again it's the interpretation of the clause, it's the disputes regarding the sampling process, the sizing issue. You know, these are not new issues.
Okay, thank you.
So this is in 2015.
Yes. So this, once again...
So, I'm sorry, Mr. Seller. So, in 2013, CDH gives an opinion where it raises these issues about the problem that Eskom did not give notice in terms of clause 3.6 in terms of quality or poor quality of coal, and that therefore it could not pursue any claim in the absence of any proof that it had given those notices. But even after that opinion, 2013, 2014, we are now in 2015, there's another opinion. Still, Eskom has not made sure that it gives the notices contemplated under clause 3.6 whenever OCM did not supply coal of the required standard. Is that correct?
That's correct, Mr. Chair.
And hence, in the 2015 opinion, the same point is still being made. Is that right?
Yes, that's correct. I think just as CDH is much more emphatic in saying we did not impose the penalties.
Yes. Yes.
You know, they saying it stronger than
Yes.
the earlier opinions.
Yes.
Even though they say they're still extracting documentation, they do say it much more bolder that we did not impose the penalties.
And one would have thought that in any event, if ESCOM was serious about enforcing penalties, at least after or by the time of this opinion, 2015 opinion, one would have thought that ESCOM would have been able, if they did have proof of having given such notices, that they would have provided those to CDH to say, no, now we do have proof. We might not have had proof prior to your 2013 opinion, but now we are wiser and we've got proof. Is that right?
That is right, Mr. Chairman. I would just also say that you must bear in mind that during 2014, there was that cooperation agreement with Glencore in place, of Glencore Optimum, and that the parties were endeavoring to sort out these issues. And they come to a conclusion, and that is then what goes to the board, and the board says, you know, Mr. Molefe must sort this out.
But
so that's the only, for want of a better word, mitigating factor that you need to, you know, just take into consideration.
But of course, everyone protects their respective positions during negotiations. You would have thought that ESCOM would say, well, we are not going to have a situation where our negotiating position, our bargaining position is weakened. If you provide us with poor quality coal, we will serve you with the notices in terms of clause 3.6. But whether or not we will impose the penalty, we will see that later after negotiations, but we can't not issue the notices because failure to issue the notices means that we lose the right to impose the penalty. We don't want to lose that right. One would have expected ESCOM to have acted on that basis. Would
yes,
you not agree?
I agree with you, Mr. Chair, and just this is my default position in defense of ESCOM at the time.
Is it because?
I think they did.
Is it because you were the legal person? You didn't tell
No,
them.
no, no.
Let's
I
do it
wasn't
this
the
way.
legal person at the time, but I'm still. Some part of me has an allegiance to ESCOM. They did try it halfway, Mr. Chairman, and I think you know that from the documentation you can see that they did put a clause in the cooperation agreement, but you are correct, they ought to have done the second bit as well in terms of the notices, given what CDH had said, and that there had been no application for rectification. So the preservation of rights clause in the cooperation agreement did not go that far.
Oh, okay. Well, you mentioned an important point because I don't recall the provisions of the cooperation agreement. Are you saying that that agreement had a clause that sought to protect ESCOM's position to the extent that during the operation of the cooperation agreement, ESCOM might not issue notices?
Yes, I just can't remember the specific wording, so I said that covered some of what you are asking.
Okay.
But it may not have gone as far as
it should. Yeah.
As it should have.
Okay.
That all I'm just asking you to to bear that in mind.
Yes.
So that would have, that is another reason why we found ourselves in the position that we did in 2016, 2017.
Yes. Okay.
I think that clause reserved ESCOM's right to claim for penalties, but after the duration of the negotiation. So you are right that we would not issue you, but we reserve that right to do so after. But then it would apply prospectively.
Yes,
Yeah.
yes, it wouldn't affect
It wouldn't affect the
the
historic.
previous one.
That's correct.
Well, that's why I'm saying it did not go as far as one would have
Yes.
expected it to go.
Yes,
You know.
but also, I guess in fairness to ESCOM, there is no way OCM would have agreed that they should cover the period before the cooperation agreement, because that would resuscitate claims that otherwise had prescribed. So OCM would not have agreed to that. Okay, all right.
And they're going to weaken that clause substantially. I think in the next opinion they show that ESCOM ultimately agreed to a specification that met the coal that was supplied by OCM. So then you can go back and say, I'm claiming,
Yeah.
when you have lowered your specification to accept the coal,
Yeah.
which was already supplied. But
Okay, we are at 6:10, so
we'll expedite it. Yes, Ms. Daniels, talking about the waiver which the chairperson alluded to, you remember that the BTC chairperson, in fact, I think it's the meeting of the 8th of February 2017, also said it means looking at this, what we have gone through now, ESCOM's failure to enforce its rights, it seems that ESCOM has waived its rights to enforce the penalties. You remember that? You remember that?
Yeah, not specifically, but I will look at the document. If you reading from the document, then it's there.
The minutes, I think, is of the
Yeah.
7th or the 8th of February 20. You don't have to go there now. We will come to it as we navigate our way through this. Let's go to the. That
And
was
sort
the
of, Mr. Chair, just to give context, that the kind of detailed explanation we did at the February meeting as well, that we are offering now.
Yes. Just go to the next opinion. I think we are on the second. You say it has raised. By the time of this opinion, March 2015, you are still not involved in this matter.
No.
Okay. We know that the third opinion, that's the one you asked for. You come on board on this.
the third opinion starts from where?
The third opinion, Chair.
1042.
1042. Okay, thank you. That's the one you're going to now. Is this
Yes.
legal?
Yes, Chair.
Okay. Continue.
Continue, Ms. Daniels.
Mr. Chair, yeah, I had asked at this point in time, I am acting head of legal and compliance, and Optimum was one of the issues, one of the litigation matters on the table, and I had asked for an assessment of the merits and just a high-level overview of what the issues were. And once again, CDH tells ESCOM the claims potential weakness are ESCOM's compliance with the contractual requirements in terms of, its failure to manage the contract, the rectification of clause 3.6, once again, that's the entire quality penalty regime,
On which
and
page?
the integrity of the sampling process. And you will find that
I think it's page 1046.
in,
Chair.
yes, 1046,
Yes.
paragraph, it's under heading 3, the ESCOM claim and its potential weaknesses.
So, Ms. Daniels, are you saying the issues are the same?
Yes, Mr. Chair, they haven't really changed.
I got the minute of 8 February 2017. I will quickly read to you. It says, the chairman opined that ESCOM had by its actions effectively given up its rights in respect of sizing, as it had decided not to...
Where are you reading from now?
That will be page 1134. Chair. Sorry, Chair.
1134.
1134.
Oh, okay. I was still on the opinion.
No, you are right there, Chair. I just wanted to read to Ms. Daniels.
Oh, okay.
Just what the chairperson of the BTC said.
Yeah.
It's 1134.
Continue.
The fourth paragraph from the top. So the chairman opined that ESCOM had by its actions effectively given up its rights in respect of sizing, as it had decided not to enforce penalties on the sizing issue. Mr. Mutley, which is the attorney writing this memoranda, agreed that from a commercial perspective, the above statement was correct. Dr. Naidu added that by virtue of ESCOM continuing to accept the out-of-spec coal, it was effectively giving up its right to penalize on sizing. So the BTC itself was raising this concern that ESCOM seemed to have waived its rights. Well, that it has effectively waived its rights to claim on sizing. You see that, Ms. Daniels?
Yes, that is correct.
But it was
That's what I say, Mr. Chair,
Yes, proceed.
that was already stated, you know, from the beginning in 2013 when CDH started opining on these issues. So the theme throughout has been, ESCOM, you have a problem. You actually can't enforce your claim.
And then, Chair, if we may go back to the opinion.
Yeah.
On page 1047. So...
Well, before you go to 1047, at 1046,
yes,
I'm attracted by 3.3, which says the issues of concern relating to the claim has always been, amongst others, the following. Ms. Daniels has been saying that it was always the same concerns, and the difference was that as time went on, CDH was becoming more and more emphatic in terms of raising these concerns. Is that right, Ms. Daniels?
Yes, that is correct, Mr. Chair.
Okay. Mr. Salega, you can go to 1047.
Then 1047, Ms. Daniels, they set out the potential defense that OCM has.
Yes.
You have looked at those as well?
Yes, I have, and they do say there is, you know, the disputes that they say there is no reasonable basis to justify a penalty of this amount, which is the 2.2 billion, having regard to the history and background circumstances surrounding the imposition of the penalties arising out of the CSA, which is called supply agreement, and that ESCOM has no reasonable prospect of recovering this amount in an arbitration.
Next point. I see
And
it.
then it also says OCM may not be able to settle the claim. And then the specific defenses was that the CSA included a renegotiation clause, which was already activated. That's in 4.1.2. And that was in April 2013, as you see from 4.1.2.2. And the fact that Optimum had actually issued that notice and that the people were negotiating, the teams were negotiating in 2013, 2014.
So in
And
other
then
words,
they do set out,
in other words, you can impose the penalties when we are busy renegotiating the specifications of coal to be supplied.
yes. You will see from the agreement, Mr. Chair, that it specifically says where there's an issue, because sizing was a problem, where there was an issue raised in respect of sizing and the supplier issued the notice, that the parties would enter into negotiation. So from that point of view, then the sizing specifications for effect was stayed and they had to renegotiate a new one. So that affected the claim that we had in respect of sizing.
Okay. Then let's go down to 4.1.2.5. I see there that this renegotiation process, they say, was eventually subsumed into the broader settlement discussions, which culminated in the signing of the cooperation agreement in May 2014, which suspended all the penalties. During the settlement discussions, there were extensive negotiations on the specifications with Primary Energy and the Hendrina Power Station, and ultimately, a specification was agreed in relation to sizing, which matches that which OCM delivered during the period from March 2012, from 2012, I beg your pardon, to 2015. If this is a specification that the power station was capable of accepting, then clearly the delivery of coal meeting that size specification during most of 2012 to 2015 could not have caused any meaningful damage to the power station. So Eskom seems to have then agreed, as I was alluding earlier, to a specification that matched the coal that was already supplied.
Yes, and therefore its claim in respect of payment reduction or penalty fell away.
Okay, well, those are the defenses of OCM. They carry on. Maybe we could go to, because we're mainly concerned with the weaknesses that were apparent from the very beginning in Eskom's claim. Let's see the next opinion. So this opinion, you requested it.
Yes.
And you obtained it. You obtained it from CDH.
Yes, I did. It was in December 2016.
Yeah, it's dated 2 December 2016.
Yes,
And
that's when it arrived.
And would you have followed the same process of raising these concerns with your executives?
Yes, this I discussed with Mr. Singh and Mr. Koko.
And you do speak about Mr. Koko's attitude here about settlement. Can you just quickly touch on that for the chairperson?
Yes, Mr. Chair. Mr. Koko was appointed acting chief executive on the 1st of December 2016. And with effect from that date, his position altered in terms of this matter, to the extent that he had told me that he'd be happy if we settled this claim at around about 500 million. At that stage, I was still saying, well, you know, how do we go from 2.1 billion to 500 million? And it would not look good for Eskom to settle. At that stage, I was making that statement, not understanding the full import of what had gone before. But from a perspective of we had gone out into the media, we had said 2.1 billion is what is owed Eskom, and we had made such an issue of it that we couldn't just walk away.
So,
Well, Mr. Koko became acting group CEO in December 2016 or early January 2017, isn't it?
It was December 2016, the formal, the board
Yeah, when Mr.
approved the appointment.
Mlefe left.
Yes.
Yeah, but how could you have said to him, how could you move from 2 billion rand to 400 and something million when you knew, based on these opinions, as you indicated earlier, that much more than 50% of this claim would be defeated by the fact that Eskom had not issued notices in terms of clause 3.6.
Now, what I'm saying, Mr. Chair, when the conversation started, that was my position, not having read all the detail yet.
Yes, but you
As
knew...
I came to know of what was actually involved.
When did you get involved in the issue of the penalties? I thought you got involved much earlier than December 2016.
I can't remember when exactly. I took over in September, and during that period, we started evaluating all the. There was about 278 litigation matters, live litigation matters, so that we were going through them. What I had asked CDH to do was do an assessment for me, and that assessment is dated the 2nd of December. So from that, we started working through it.
Yes.
So I hadn't yet had the opportunity, like the detail that I'm giving you now. You will see that the memo for 2 December has all of these opinions attached to it. So when I started the conversation with Mr. Koko, it wasn't having had full insight into all of this. My insight was based on, we had, from a company perspective, we had gone out and said, we are claiming 2.1 billion. How do you get to 500 million? You know, not from having read all of this. I then started going through all of this when I received it.
When did you become head of the legal department?
I took over from Mr. Solanko in September.
In September 2016?
Yes.
Yes. So are you saying that as in December, before you actually got this advice or opinion of 2 December 2016, until you had a chance to read it and see the previous opinions, you were not aware of the previous opinions?
No, I was not. They were all attached to this December 2016 opinion that I got.
I would have thought that your predecessor would have made sure such important opinions were made available to you when you came in. You say that was not the case.
It was actually not the case, Mr. I would have thought so too, but it was actually not the case. It was only when I got this, you will see from the memo in the bundle that all of these memos were attached to the December 2016 assessment. And it was at that point that I could then read through all of those memos, including the technical reports.
But I thought that you said earlier on you were present at a meeting involving somebody from CDH where Mr. Mlefe was present and where he was cautioned about talking about a claim for 2.1 billion rand because there was a problem with the fact that Eskom had not given notices in terms of clause 3.6.
Mr. Chair, I was present at the meeting. I did not have the documentation. All I know is, from what I recall from that meeting, he was made aware of the issues relating to the claim.
Yes, but if he was made aware, he was made aware in your presence, and if you were not one of the people who were making him aware, it means at least you became aware that this 2.1 billion rand claim was problematic because you were there when he was cautioned. And that would obviously have been sometime, or that would have been before Mr. Koko took over, before your discussion with Mr. Koko. So by the time you had a discussion with Mr. Koko, even if you may not have read this latest opinion that you obtained, you would have known that there was this caution that was given. And I would have thought that once you were told about, you were aware of the caution, you would have known that the caution was based on opinions and you would have wanted to see those opinions if you had not already seen them. And how could you not have seen them before they were attached to this opinion?
I was not in a legal capacity in that stage, Mr. Chairman. So I always knew that there was an issue from that stage, but I didn't know the exact ambit of the issues, and that is why I asked for the assessment.
Yes, but I mean, what position did you occupy at the time of that meeting involving somebody from CDH, yourself, and Mr. Molefe? What was the
At that
position?
stage, I was still in group commercial.
Group commercials. That would have been 2015 or 2016. Are you able to say?
It probably would have been around about 2015, because I became company secretary in October 2015.
Yes, but you see, I may have difficulty with the idea that you are present at such a meeting where Mr. Molefe is cautioned the way you said he was cautioned about this claim, but when you become head of legal, nothing says to you, but I must see those opinions because this is a very big claim. This is quite an important claim.
But that is why I asked for the assessment, Mr. Chairman.
No, I understand asking for that, but before you asked for it, I would have thought that you would have wanted to see the opinions that were in existence already, that caution was based on. In other words, you'd say, I remember that meeting, this was the caution given, and let me see those opinions first. Because those opinions could have an answer for you. Then you don't have to pay for another legal advice when there are opinions that give you the legal advice.
But they were all attached to the CDH opinion anyway.
Yes, but what I'm saying is, if you remembered that this claim, it was in regard to this claim, that at a meeting that you attended, Mr. Molefe was cautioned and told that don't be too strong on this 2.1 billion rand claim because it's problematic because there were no notices issued by ESCOM. Seems to me that probabilities are that you ought to remember when you are head of legal that this claim, I remember we told Mr. Mulaf there is a problem, and to the extent that in that meeting you would have been aware that there were legal opinions that had already been furnished, I would expect you to want to find those opinions even before you could ask for another one, because why would you want to pay for another opinion if you have opinions that already give you the answer that you are looking for?
Mr. Chairman, I just want to maybe correct the opinion. This wasn't in isolation. I did have these conversations with Mr. Moodley, and that is why I asked him for an overall assessment. You see, not just an opinion, and that is why he attached all those opinions to the assessment that he gave me.
Mr. Slager?
Yeah. Did you engage with Mr. Bester in regard to these opinions, Ms. Daniels? Because I saw the first one was addressed to him.
Mr. Bester was not at ESCOM at that time, Mr. Seleka.
Oh, he had already left.
He had already left.
And Mr. Solanku, or Advocate Solanku?
We didn't get a chance to talk about the optimum arbitration in this detail. And basically what I had to do was, ask, CDH was the primary energy advisor, and I had to ask them. The legal advisor that was involved in the matter had also left ESCOM. So it was having to go back and ask the external advisor to provide me with the issues and then compare it to what we had.
So you were saying Mr. Koko was expressing the view that a settlement, he will be happy with a settlement at 500 million rand. Did you, apart from saying, well, we've already made a song and dance about 2.1 billion, did you have any specific amount in mind?
No, not at that stage. As I said, I hadn't read all the opinions yet, and I hadn't familiarized myself with the depth of the issues. My issue was more from a corporate perspective that we'd gone out. We had said we were going to do this, and this about turn, just was not good from a corporate perspective.
Was this the first time he expressed the view of a settlement at 500 million?
Yes, this was the first time that he expressed it to me.
Okay. Okay. Are you able to move on to the fifth or the fourth opinion? We know that you ultimately approaches BTC. That meeting I've referred to on the 8th of February 2017. Mr. Moodley was also there. Is it you and him, or just him, who took the BTC through the issues that had been raised in their memory?
I was at the meeting, Mr. Chair, but I had asked him specifically to come because of his involvement in the matter as ESCOM's legal representative. By that time, I had now had the opportunity to go through all the issues, discuss it with him. The arbitration, I think we had initiated it again. But given all these issues, like I said, that I was not, I was not comfortable going ahead. We now had, we did not have any witnesses, physical witnesses at this point in time. You know, the proof of the claim was now clear that how do we prove this? And we had a change in attitude by the executives, and you know, I was not comfortable making that decision on my own.
What was the decision?
Well, to settle the matter.
So that was discussed at this BTC meeting on the 8th of February 2017.
Yes, I wanted a specific mandate, if that was to be the case, to then settle, because settlement, I think the attorneys for Optimum did initiate a settlement, and when we got to the settlement discussions, and when we got to the arbitration, the arbitrator also asked, as a standard practice, would the parties consider settling the matter?
Was BTC the right committee to approach in regard to this issue? Because BTC was kind of pushing you back, saying this is not a procurement matter, it's a litigation matter. Why are you asking for our approval?
We are
In respect of the 134 million, I must just look at my notes. I think you will have to listen to the tape, but it was around the 134 million. And then I said that the CDH opinion would be in respect of the future payments.
But did you tell the BTC what the opinion was saying about is it the 34 million?
134.
The 134 million.
Yeah. Did you tell the BTC what your legal opinion said that you said you had obtained or received or got?
I don't think I said it out. You can hear on the tape. I think it was, I said it was payable, but I don't think it was in respect of the legal opinion. I just need to listen to it again. We listened to it, I think it was yesterday,
Okay.
Mr. Chairman.
Mr. Selega, what's your recollection of what emerges from the audio, from the tape, in terms of
Yes.
what she said about the opinion about the 134 million?
Yeah. Ms. Daniels didn't specify what the opinion says. What she says is Oliver Wyman did the financial assessment. So in respect of the claim that McKinsey and Trillion has, Oliver Wyman did the financial assessment. An internal audit was done by Molefe and Company. And then she says, I got Cliff Decker to give us legal review. Then she says something, it's not clear what she's saying, but effectively in respect of the payment sought to be approved. And she goes on to say, and for the remainder, which is the remainder of the amount, we will get a legal opinion on how we deal with that to protect ourselves. But the details of the opinion are not given. But the paragraph in the submission drives the point.
In the submission that was given to the BTC.
To BTC.
Yeah.
There it is very clear that what is conveyed is that Cliff Decker have been retained to give advice that Eskom can settle with McKinsey and Trillion and pay the settlement amount, and it will avoid further claims. So this becomes the basis on which BTC approves the payment of 134 million.
Yes. Is there anything that was said about the legal opinion that may have influenced BTC to settle?
In
terms of the context of the discussion? No.
That submission.
Or in terms of the submission, yes, and or the discussion in the tape?
Yeah, you hear Mr. Zitembe Koza saying, we have obtained external legal opinion, they've checked the contract. Deloitte have looked at the figures. Deloitte have recommended payment now of a figure and payment in the future of another figure. So, that says, okay, the lawyers have looked at it, the accountants have looked at it, and this is the figure we have to pay now. Other figures will be paid in the future. The closest you get what the lawyers are allegedly saying, it's in the submission, paragraph 8 in the submission.
Yes, and that says?
That says that they are advising that you settle with McKinsey.
Yes.
Pay them the amount so that you avoid future claims.
Yes. Okay. And that submission had been prepared by Ms. Daniels or by somebody else?
Ms. Daniels, who prepared the submission?
Can you recall?
Mr. Presh Gamada prepared the submission, Mr. Chairman. As I'd indicated at the previous occasion, that was done in anticipation that it would have been completed. But by the time we got to the meeting, it was not completed.
Yeah, but wait. Is this not the submission that you also signed?
Yes, I did sign it.
Is this the very submission that Mr. Koko says he refused to sign?
Oh, no, sorry. Those are two different things, Mr. Seleka, Mr. Chairman.
Okay, but let's concentrate
Those are
on
two
this one.
different things.
Let's concentrate on this one. Who signed this one?
This was signed by Mr. Govender and I think Mr. Singh and Mr. Mabalani.
Oh, you didn't sign it?
No, I did not sign this one.
So you were mistaken earlier when you said you signed it. We're talking about
No,
another one.
I was talking about the
other one.
memo later that we spoke about, Mr. Chairman.
Oh, okay.
But in terms of this December submission, I did not sign it.
Mm-hmm. Did you have any input in it, even if you didn't sign it?
Yes, as I said, that clause in respect of the legal review, as I testified earlier, that was done in anticipation that it would be completed, but it was not completed by the time we got to the meeting.
So that's the clause that says what?
If you can just.
It's quoted in Mr. Moodley's affidavit. I recall he quotes it because he complains about that aspect. It's page 943 of the same ESCOM bundle 14 bracket D.
Yes, just go ahead and read.
It reads under paragraph 96. He quotes 8, external legal review.
I'm sorry, you said 9?
943.
Okay.
943 says Cliff Decker Hofmeyer, this is clause 8, was retained to conduct a review, and the conclusion is that ESCOM needs to enter into a termination agreement with the parties to bring the matter to finality. This will absolve ESCOM from any further liability once the termination agreement is in place. It's quoted under paragraph 96.
Yes, okay. Yes, okay, all right.
So that's the critical point.
And this was provided on the 12th of December 2016. This external legal review.
The review, Chair, the review wasn't granted, wasn't given at that stage.
Oh, that is when.
So.
Okay, no, I can see.
Yeah, what Mr. Moodley is saying here is they are busy drafting the submission internally in ESCOM. He gets the submission on the 12th of December. And he sees this paragraph 8 inserted in the draft document. And it should not be there because he hasn't given a legal review or legal opinion. Yes. So he says then he raised the issue with Ms. Daniels.
Okay, this is the clause that you said makes it clear in the submission.
Correct.
Yes. Well, certainly, Ms. Daniels, here this clause was saying that Cliff Decker has given an opinion to the effect that ESCOM should enter into a termination agreement to bring the matter to finality. And that was factually not correct. Is that right?
That's correct, Mr. Chairman, and that's why I said, the last time that I'd done that in contemplation, that it would be completed, but it was not by the time we got to the meeting.
But how would you have known what conclusion Cliff Decker would reach? You asked Cliff Decker to give you an opinion. If you haven't received their opinion, you can't know what conclusion they will reach, isn't it?
Yes, that's correct.
Yes. And therefore, you can't say to the BTC what their conclusion is going to be on the basis that you expected, or your explanation can't be that I expected that their opinion would have arrived. Because even if you expected that their opinion would have arrived by the time of the BTC, you would not know what their opinion would be. So you couldn't start preparing a memo that says what the opinion is. If you wanted to say anything, you might say, I've asked for an opinion, I haven't got it, but my view is that it's likely to say blah, 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 blah. But you can't begin to say what that conclusion will be. And here you say, and the conclusion is that ESCOM needs to enter into a termination agreement. So in other words, what I'm putting to you is, when you say to me that you put in this clause in the submission on the basis that you thought by the time the BTC set, the opinion from Cliff Decker would have arrived, I'm saying that that's not convincing to me, because you have asked them for an opinion, but you don't know what opinion they will give you. Therefore, you can't tell the BTC what the opinion says or will say. What do you say to that?
I accept that, Mr. Chairman. I should have made it, I should have said it differently.
But it goes beyond that. It gives the impression that you may have deliberately sought to misrepresent the position to the BTC. Because for the reason that I've just been giving you, that if I've asked you for an opinion, until I get that opinion, I don't know what you will say. And therefore, I can't say to Mr. Selega, you have reached this conclusion. I can't say, before I get it, what you will say. I'll have to wait until then. Can you understand?
I understand what you're saying, Mr. Chairman, and I do accept it. I mean, now looking at it in the cold, hard, objective light, I do realize that it did not come across as I had intended it to, and I do accept responsibility for that, and I do apologize for that. There was no deliberate intention on my part to mislead anyone. You know, but having listened to both the audio, you know, and also reading it, and your questioning now and Mr. Seleka's questioning, I do accept that, and I do apologize.
Mr. Selega?
You see, Dr. Koza, who comes before Ms. Daniels in the audio, talks along the same lines, Ms. Daniels, about the legal review or a legal opinion being obtained. But let me say this also, because your statement to the BTC went further to say that in regard to the remainder, we will get a legal opinion. But you know the remainder, which is the amount that was yet to be paid. Those amounts were paid even, again, before the legal opinion was obtained. That legal opinion was received on the 17th of April 2017 and finally on the 28th. Did I say April? Sorry, February.
February.
Yeah. And then the final one on the 28th of February. But payments to Trillian and McKinsey had already been done. The last payment.
But you'll remember that that instruction was provided to settle by Mr. Governor directly to CDH to settle, and I think the invoices were signed off by Mr. Governor and Mr. Mabalani around about the 14th. So they didn't wait for the legal opinion to come in.
Yeah, that's another problem, isn't it?
Yes, it is.
So Mr. Salim Esa's company was paid without Eskom having obtained a legal opinion that it shouldn't pay, which is what the opinion ultimately alluded to.
That's correct. And he, well, the opinion went further than that and said that Eskom should not have paid in its entirety.
Well, Ms. Daniels, this clause and what your evidence is about how it came about troubles me. As we speak, is your position that with the questioning that has happened, you still maintain that you didn't intend to say to the BTC, Cliff Decker had concluded in the way that the clause says, or do you accept that you did intend to convey that to the BTC? I ask that because you did say earlier on you take responsibility, I think, for the clause. And I did say earlier on that it seems difficult for me to accept that you could say, you could write that Cliff Decker had concluded that Eskom needed to enter into a termination agreement without intending to convey that to BTC, to the BTC. So I just want to let you tell me once again where you stand about it. You still say you didn't intend to convey that, or do you say, look, I accept that that's what I intended to convey?
Mr. Chairman, I think I want to answer it this way. I accept I shouldn't have said that. Okay. I accept that it it is as it is phrased there, it is deliberate. All I'm saying to you is from my perspective, there was no intention to mislead. I should have looked at it more closer.
Okay, all right. Mr. Selega?
Yeah, I think I've reached the end.
Yes.
I know Ms. Daniels wanted to give you evidence on certain things.
Yeah.
But we are now nearly at 7:30.
Yes, but I wanted to finish with her evidence today. What were the other matters? I know there is the issue of the pre-suspension letters.
Yeah, she wants to address you on that.
Yes. Is there something else other than that? From your side, you are done. It's just that she wants to.
Yes.
Or did you not want to? Okay. Let's talk about those pre-suspension letters, Ms. Daniels. I think Mr. Koza, Mr. Zatembe Koza, when he testified before the commission, said that those pre-suspension letters had properties which suggested that they were in your computer on the 10th of March 2015, as well as in Mr. Salim Esser's computer on the same day. Yeah, I'm sure you heard about that part of his evidence. What do you say about that?
Mr. Chairman, I just want to repeat that it was a template that was created by me, not the suspension letters, but it was an ESCOM letterhead template, and that was used to generate those letters. I don't accept. I reject what Mr. Koza says in terms of the fact that I worked with Mr. Esser on those letters. At the time of the creation of those letters, I was actually in Pretoria in a face-to-face discussion at my home with Mr. Marokani, and telling him what had happened on the earlier that afternoon.
Those suspension letters that Mr. Koza was referring to, do we have them in one of the bundles here or not? The ones he was talking about?
Yes. Sure.
Because if we've got them, I would like to see them, because I want to see whether they are just templates or they've got information relating to the individuals who were suspended on the 11th.
The pre-suspension letters.
Yeah, that Mr. Koza refers to.
Yeah. They have the information, they are individualized.
Yes.
They have Mr. Matona, Mr. Marokani, Mr. Koko,
yes,
and they have information pertaining to them.
Yes.
It is the metadata,
yeah,
which then shows who's the author and who's the last modifier.
Yes.
Yeah. I know we have put those questions here, but I don't think we have the file.
Okay, no, I don't need to see them because what you have told me is enough.
Yes.
Now, so you say, Ms. Daniels, you know when they were created, those letters, and at the time that they were created, you were not at ESCOM, you were in, or rather, no, you said you were in Pretoria. Okay. Now, no, I don't know a lot about technology, but is in terms of when they were created, is that what you see from the letters themselves, the properties, the metadata, or whatever?
Yes, Mr. Chairman, and that is why I can tell you, because I think it says, I don't remember exactly the time, but it said 6:38 p.m. And this is from the metadata. Like you, I've learned a lot only learned about it through this process. It says, and also when you create a template, the creator would always be myself. That could also be, when I created the template, you'd see it created by Suzanne Daniels, and, you know, then people can change it. But I looked at the timing of the creation of those letters, and at that time, I was speaking to Mr. Marokani face to face.
They have been created from your desktop and not from your laptop.
When I created those letterhead templates, they were stored on my ESCOM computer. So at that stage, I think I had a laptop.
Yes, but what I'm suggesting is, if they were created in your laptop, the fact that you say you were in Pretoria with somebody might not have any significance, because you could have created them wherever you were if it was a laptop. But if they were created on the desktop and you say you were not at ESCOM at that time, that might have credence.
Well, what I'm saying to you, Mr. Chairman, is that I could not possibly have been on my laptop either at that time, because I was face to face in a conversation with Mr. Marokani, and that conversation lasted quite a while.
About how long? An hour, 2 hours?
I think he was at my house for about an hour.
Yes, and the time when they were created fell within that period.
Within that period, Mr. Chair.
Yes, but in terms of whether they were created in the laptop or on the desktop, is there clarity on that?
I don't think you can get that from the documentation. I certainly, don't have them. And from what I can see from the forensic, Mr. Seleka gave me Mrs. Klein's affidavit as well, and her forensic investigators confirmed that it was from a letterhead template. So, that's the best. I'm not a forensic scientist, so
yeah,
we will have to wait for that. But from what I'm saying to you is, at the time of the creation of those letters, from what I see, I was not physically with Mr. Essa or working with him, because I was actually relaying the events to Mr. Marokani face to face at my house.
And did you say the time was 6:30 on the 10th of March?
I think it was it says on 6:38 or 6:40 on those letters. And that was the time that Mr. Marokani and I were in conversation.
And that is PM?
PM, yes.
Yes. And you say you would have had, so is the position that what's important is that you were busy with somebody as opposed to being away from ESCOM? That is important.
Yes, I think just, as we know, these documents can be done anyway. What I'm saying is, physically, I was face to face with Mr. Marokani, and he can tell you that at no stage did I step out to go and do something. I was telling him what had happened that day.
Or is that when, according to your evidence, you told him about your meeting with Mr. Oko and with Mr. Salim Essa?
Mr. Essa, yes.
Okay. All right.
So I could not be drafting suspension letters or pre-suspension letters with Mr. Essa when I'm talking to Mr. Marokani about what happened earlier that day.
Yes. Now, Mr. Seleka, is there anything else about these suspension letters? that you think needs to be clarified? I know that more investigation must be done.
That's right, and we are nearly at the end of that.
Yeah, okay.
Yeah.
So it may be that she might be asked in due course to comment once the investigation has been completed.
Yes.
Yeah. Okay, all right. Can I go back to the issue of your meeting with Mr. Koko and Mr. Salim Essa, which is your version, on the 10th of March? On that day, was it your first occasion to go to those offices where you met Mr. Koko and Mr. Salim Essa?
Yes, Mr. Chairman, that was the first time.
Did you subsequently ever go to those offices after 10 March at any stage? Before you gave evidence before the commission?
No, not to those offices.
Yeah, not but to the, even if the company had left, but to that spot. Did you ever go there?
No, not to that spot. The Trillion offices, they moved about a block
Yes. Now,
forward.
So is your evidence that therefore maybe between 10 March, before 10 March, you say you had never been to those offices?
No, I'd not been to those offices.
And since then, and during the time when you have been giving evidence from time to time to the commission, have you gone there again to identify where the offices were, where you met them, or have you not?
Yes, I have, Mr. Chairman. I have been with the investigation team to show them where it was.
Yes. Have you signed an affidavit after that to say what happened when you went there to identify the place, or not yet?
I haven't been asked to do that, but I am happy to do that.
But were you able to remember where the offices were where that meeting was held when you went again? Yes. Okay. Are there any features that made you remember? Or anything that made you remember? I mean, so many years after, if you didn't go there again in 2015, 2016, 2017.
No, but sorry.
Mr. Chairman, the offices are fairly standard from the outside.
Yes.
The feature was that it was quite close to the entrance, and I could remember that.
Yes.
And I mean, that was such a
So
it was such a life-changing moment, in the course of the last couple of years.
Did you recognize
that it's actually very difficult to forget.
Did you recognize the place where the offices were in the building without anybody's assistance?
Yes, I did.
Okay. Mr. Selega, you wanted to say something?
To Ms. Daniels, I remember from your affidavit that there was another occasion you say Mr. Koko drove with you to these offices. He went into a boardroom with Mr. Salim Essa and left you at the reception area. Was that before or after the 10th of March 2015?
That was after the 10th of March, Mr. Chairman, but by then they had moved to another office. That's what I'm saying, that office was a block away. I understood Mr. Chairman asking me had I been back to that, the 10th of March office.
Also, the occasion that Mr. Selega refers to, which is a different occasion from the occasion of the 10th of March, you went with Mr. Koko to different offices, but where he went to see Mr. Salim Essa. but
Yes,
just
that is
different.
correct, Mr. Chair, and it was still at Melrose Arch,
Yes, and the same building or a different building?
a different building.
Yes, okay, all right.
And then there was one on a Saturday where Mr. Essel gave you a telephone call and asked you to come and meet with him at Melrose Arch. Was that meeting at a different place in Melrose Arch or the same place?
That was at a different place. We met at the African Pride Hotel, the reception there, and then we walked to what I then came to know was it was an apartment block.
Mm-hmm. Mr. Saleh?
Yeah.
Is that the one where there were other people?
Yes, Mr. Chair, that is where I saw Mr. Ajay Gupta and Mr. Dutazani Zuma.
Yeah,
And
I remember you testifying about
yes.
that. You
And
done?
then- Yeah. I know the pre-suspension letters, we had touched on that on, I think, the second or the third occasion when she appeared.
Oh, okay.
But I did want to come back to it once we have the expect
Yeah, no,
affidavit,
that's fine.
which we will, in any event, have to come back to it.
Yeah. I guess, depending on what the expert says. Yeah. Okay, all right.
Yeah.
Other than what you have been able to say now, Ms. Daniels, in response to my questions about the issue of the, pre-suspension letters, was there something else you wanted to say about them?
Not specifically, Mr. Chair. I think I've covered them in my affidavits and my previous testimony. I just wanted to highlight, that the new information, because I checked with Mr. Marokani on the times that we met.
Okay. Okay. Well, we are going to adjourn. And as I understand the position from Mr. Selega, he is done with your evidence, except insofar as the further investigation about the pre-suspension letters might make it necessary to call you back or ask for your comment arising out of whatever the further investigation may reveal. He is done. Therefore, unless there is something else you want to say, I am ready to thank you and then to adjourn.
There was just one other issue that I wanted to bring to your attention, Mr. Chairman.
Yes.
It is in my affidavit, but I just wanted to raise it with you, or just, highlight it to you.
Yeah.
I have been provided with the affidavit of Mr. Koma, Kulani Koma, who was the board spokesperson at the time during the tenure.
Is that comma?
And
is that comma?
That's right.
Okay, that's what's his name?
yes, that's
Kulani.
correct. That's
Kulani.
Oh,
Kulani.
okay, yeah, Kulani comma, yes. Comma will be Q-O-M-A,
and-
is that right?
That's correct.
Yeah, just for the transcribers. Yes,
That's
continue.
correct.
Mm-hmm.
Okay. So in his affidavit, he talks about Mr. Koza bragging about how he stopped Mr. Koko's suspension. This is the suspension in 2017, March 2017. So I just wanted to give you context that the events that led to that was that Miss Minister Brown provided information to Ms. Dr. Ngubani, and I go into detail, so I'm not going to go into, in my affidavits, I'm not going to go into too much detail here unless you ask me questions. Minister Brown asked Dr. Ngubani to investigate a number of companies. One of them was a company that had gotten a tender for 200 and something million, and then it had grown to over $1 billion. In that investigation, it ended up that was the company that Mr. Koko's stepdaughter then owned, and the board subsequently instituted an investigation. At this point in time, there were in March 2017, there were other complaints about Mr. Koko. It was discussed at a meeting of the People and Governance Committee, and the committee decided to issue a notice to Mr. Koko to explain the allegations and give him, follow a sort of pre-suspension process. And in that case, in that instance, I did draft the notice of pre-suspension for Mr. Koko. It was the 1st of March 2017. The meeting was scheduled to take place at 6 o'clock that evening. Members of the board were there, so I drafted the notice and we attached the memorandum. Ms. Dr. Ngubani, the meeting took place, long story short, Mr. Koko was not suspended at that meeting. Mr. Koza, and this was in Mr. Koma's affidavit, Mr. Koza explained to Mr. Koma that he stepped out of that meeting and phoned one of the G brothers, which we know.
One of the G brothers?
One of the G brothers, which is one of the Gupta
Who are the G
brothers.
brothers?
Excuse me?
Who are the G brothers?
The Gupta brothers.
How is that how you call them?
Well, that's how Mr. Koza called them. He said he called one of the G brothers.
Oh, that's what he said. It's
That's
not
what he said.
It's not what you say.
That's
You're
not
just.
that's not what I said.
Okay.
So-
all right. Okay.
I'm going to confirm for you. So he said he had called one of the G brothers. One of those G
or
brothers
rather,
called.
that's what Mr. Koma says Mr. Koza said.
They called. Minister Brown then called. Purposes in his office as the company
Both
secretary
of
and
you.
the board spokesperson. And then we met with him to have lunch. And Mr. Koma then relayed to him what Mr. Koza had told him in my presence. So it was at that point that Dr. Ngubani burst out laughing and said, that's exactly what happened in the meeting. He could confirm that Mr. Koza had stepped out of the meeting. He had come back. Dr. Ngubani then did get a call from Minister Brown, and that is why Mr. Koko was not suspended on that day, because he was instructed to hold the suspension. So I just wanted to confirm that what he said was actually how we related. Dr. Ngubani did not express any. He was just saying, yes, that is how it happened. He did not express an opinion on that Koza called the Gupta brothers.
Now, You say in your affidavit you deal with what Mr. Koko was supposed to be suspended for.
Yes.
Well, I assume Mr. Koko has been given your affidavit. So what was he supposed to be suspended for? Or why was he supposed to be suspended?
There were complaints. He had to answer about tender manipulation, workplace bullying. He was undermining the various tender committees, operations, and things like that. There was a detailed memo that was attached to the notice of
Do we have
suspension.
Do we have that memo by any chance, Mr. Selega? In the bundles?
Not in the bundles, Chair. It's a matter that I don't think the investigators have investigated.
Yes.
It's a matter that deals with the intended suspension of Mr. Koko in 2017.
Yes. Well, the only reason I'm interested in is that you remember that in 2015, Mr. Koko was the only executive who returned from suspension.
Yes.
The other executives did not return. And that seemed to give him preferential treatment to the extent that the others might not have preferred to leave. And I'm wondering if, when there was cause for him to be suspended, there was intervention. Yes. You see, if the position is that in 2017, when he was suspended, when he was supposed to be suspended, part of the reason why, or the reason why he was not suspended is because either a Gupta brother intervened or the minister intervened in circumstances where the board should have suspended him. It might have a bearing on whether his return in 2015 might be because of any relationship he might have had with a Gupta associate, such as Mr. Salome Essa is alleged to have been, because Ms. Daniels and Mr. Abraham Masango have said he called them separate occasions to a meeting with himself and Mr. Salome Essa at Melrose Arch on the 10th of March, where they talked about the suspension. They told them about suspensions, that is Mr. Salome Essa and Mr. Koko, told them about the suspensions of the executives that were yet to happen, and that maybe some members of the board didn't know anything about it yet. Now, of course, he has denied that. Such meetings took place. But if after I've heard all the evidence, if I were to conclude that indeed those two meetings did take place on the 10th, the next question would be, did that relationship influence anything, how he was treated, and so on and so on. So
we'll get into
it may be important to collect at least the basic facts in relation to that.
Yes.
So, but what you were saying, Ms. Daniels, is you were present at a lunch at which Mr. Koma and Dr. Ngubane were present, where Mr. Koma mentioned this issue, which he has dealt with in his affidavit about Mr. Zetembe Khoza. And Dr. Ngubane did not deny or question that, and instead confirmed that that is what had happened.
Yes, that is correct, Mr. Chair, and I do put more detail in my affidavit, but that is the correct.
And you say, indeed, the board did not suspend Mr. Koko, despite the fact that documents had been placed before it, which indicated that he should have been suspended. Is that correct? Is that what you say?
That's correct, Mr. Chair, and I would also go further. There was a unanimous decision by the People and Governance Committee to
Yes.
proceed on that day.
That he should be suspended? Or
That
what?
he should be, that suspension proceeding should start. And that's why I prepared, the notice to, the first one is we intend to suspend you. You have 48 hours to respond to these allegations.
And I guess there ought to be minutes of that People's and Governance Committee.
Yes,
that would
there
have
are
that.
minutes, and
Yes. Okay.
the recording is also available.
There's also the recording. Now, you said after the meeting, Dr. Ngubane returned the memo or documentation back to you that had been given to him that related to the proposed suspension. Is that right?
That's correct, Mr. Chair.
You did not attend that board meeting, did you?
No, I was
You were
I
head
was
of
asked to be
legal.
on standby, but I was not asked to record it.
Yes.
I wasn't present.
Yes. Who would have been company secretary at that time?
I was the company secretary,
Oh,
but this
doesn't the
this
company
was just
secretary
a
always
meeting
attend?
of the board members.
Oh, it was an in-committee. Is it called in-committee?
Well, not even an
when they want to
in-committee, I think
exclude you.
they just
When they want to exclude you.
yes, they just excluded because I was told to be there for the meeting.
But that isn't there
Then
a
they told me no.
Isn't there a legal provision that says the company secretary should always be there in a board meeting?
It's not a legal provision, Mr. Chair.
Yeah. What is it?
It's not binding.
What
but
is it?
It's best practice that the company secretary should.
No,
Be present at
no.
the
I think I've
meeting.
seen something. I just don't know whether it's a law or an MOI, memorandum of incorporation, and I don't know whether it was in regard to ESCOM or in regard to Transnet or in regard to Denel. But I seem to think I've seen something that is to the effect that the company secretary should attend or is entitled to attend board meetings.
No, I was asked to not attend. I was asked by Dr. Ngubane to be on standby, but I was not in attendance.
Did you ever see the minutes of that meeting afterwards, of that board meeting?
There were really no board minutes of that meeting.
Or when the
I can
company
check.
secretary is not there, they don't take them? They don't take minutes?
Mr. Chair, that became a chat with Mr. Koko. If the evidence of the board members, they did testify about it at the parliamentary committee.
Okay.
Because, but it wasn't then a formal meeting. They just they gave it to they did give the memo to Mr. Koko to then comment on.
But you said Dr. Ngubane told you that he would tell you later why they didn't suspend or did not act in accordance with the memorandum that you had given them.
Yes, that is correct, but he didn't get a chance. I think the circumstances overtook.
So he left before he could tell you.
Yeah, he didn't tell me the full, but at that lunch, he then confirmed that this is how the events unfolded at that meeting.
Yes. And you left in October 2017, you said?
Yes, it was.
So by the time you left, had that matter or had those allegations been further investigated at ESCOM? Had anything happened or nothing ever happened about those allegations?
Mr. Chairman, some of the allegations were investigated.
Mm-hmm.
I'm not sure what the outcome was.
Mm. So you don't know whether the board might have said, well, we are not sure that this issue has been looked at properly before we reach the stage of asking him, that is Mr. Koko, to make representations why he should not be suspended. You don't know whether they might have said that, but based on what Dr. Ngubane said at the lunch, when Mr. Koma was there, you say the position seems to be that Mr. Koko was not suspended, or that notification was not given to him because of the intervention of either the minister or somebody from the Gupta brothers.
At that point, yes, Mr. Chair. What did happen, pardon me, what did happen was the board did investigate the matter of the impulse, the impulse.
Was that
trading.
one of the
that
issues?
That one was investigated.
Was that one of the issues?
But that wasn't one of the issues on the memo.
Yeah, okay. But just to remind me, did Mr. Koma at that lunch meeting, during that lunch, did he say Mr. Zetembe Koza said he had phoned one of the Gupta brothers about this proposed course of action against Mr. Koko, and that Gupta brother had phoned the minister, and the minister had phoned Dr. Ngubane, or did he say, Mr. Koza said he phoned the minister and the minister phoned Dr. Ngubane?
No, what he said was, at the meeting of the 2nd of March, Mr. Koza said to him, this is what, he was in the meeting of the 2nd of March with the board members and Mr. Koko. Mr. Koza said that he left that meeting, he stepped out of that meeting, and he called one of the G brothers.
Yes.
To tell them what was happening.
Yes.
He then came back into the meeting. It was one of those G brothers who phoned Minister Brown.
Mm-hmm.
And Minister Brown phoned Dr. Ngubane in the meeting and told him to stop the suspension.
Mm-hmm. Okay, all right. That's fine.
Yeah.
Mr. Siliga?
Chair, I wanted to find out from Ms. Daniels, because I heard her mention there are minutes and the audio is available. So, but here lately she was saying there are no minutes of the board. So which minutes did you say are available in the audio?
The minutes of the meeting where the decision to suspend Mr. Koko is available.
Oh, so the meeting of the meeting to execute the decision is the one which doesn't have minutes.
Yes.
Okay.
Okay, it's the minutes of the P&G committee that you say are available. which said Mr. Koko should be suspended. It's the minutes of the meeting of the full board that you say are not there. Is that correct?
Yes, Mr. Chair, the PNG took place at around about lunchtime that day.
Yeah.
The meeting with Mr. Koko took place in the evening of the same day.
Okay. Okay. It's
And
the
it's the
evening
meeting, I have
that-
I have the minutes of the meeting of the lunchtime meeting, for want of a better word. I just can't remember what time it was. Where it was a unanimous decision to initiate suspension proceedings against Mr. Koko. The meeting of the 6th of, was not a full board meeting
Yeah.
of the 6th of,
But it was a
at 6
board
p.m.
meeting.
that evening, but that meeting was not minuted.
But you say it was a board meeting.
It was board members. I'm not sure how many board members attended that meeting, but it was definitely Dr. Ngubani, Mr. Koza, and Mrs. Klein was there.
Okay, all right. Did you say you do have the minutes of the PNG meeting, lunch meeting?
Yes, I do.
You do. Okay, so Mr. Selega can get those from you. Okay, no, that's fine then. Thank you very much, Ms. Daniels, for availing yourself quite a number of times. We appreciate it. So as I said, it may be that you might still be asked to deal with something arising out of the further investigation relating to the pre-suspension letters. But other than that, thank you very much.
You're welcome, Mr. Chairman.
We are going to adjourn then. And tomorrow, I already made the announcement that we'll start at 10, and we will continue with Mr. Symington's evidence, and thereafter it will be Mr. Van Lokkerenberg who will be giving evidence. That's for SARS. And then in the evening session, I will hear the evidence of Mr. Anoj Singh.
Correct.
Yes.
Yeah.
We adjourn.
Thank you.